Good morning, everybody. Welcome to Columbia University and to today's exciting program in honoring the 70th anniversary of Brown versus Board of Education. Today's event, with all deliberate speed, the past, the present, and the future of racial equity in education. Thank you so much for coming, and thank you as well to those who are joining us online. My name is Anthony Mejia, and I'm a second-year law student here at Columbia University, and I have had the immense pleasure over the past several months of working with Brown's Promise, as well as the Legal Defense Fund, to bring our shared idea of a day of panels and discussion to life. We're incredibly thankful to both LDF and Brown's Promise, as well as to the staff here today from Columbia, from the student volunteers to event management personnel, and everyone in between. Before we dive into today's programming, I'd like to begin by acknowledging the Lenni Lenape and Wapinger land on which we are on today. As we gather today to recognize and honor the past and enduring legacy of Brown, we also recognize the indigenous Lenni Lenape and Wapinger people of Manhattan, who lived on this land before and during the colonization of the Americas. We recognize their displacement, their dispossession, and continued presence. We are reminded to reflect on our past as we contemplate our way forward to support Indigenous people and other marginalized communities of this land and advance our commitment to justice. Now, we're here today to commemorate the 70th anniversary of Brown v. Board, to remember the fight for desegregation and celebrate those who fought for educational equity in the past. Fitting that we're here today at Columbia, the training ground for many of those early advocates like Jack Greenberg, who fought alongside Thurgood Marshall in Brown and led LDF as its second director counsel for over 2 decades thereafter. As the name of the event suggests, our focus is not only on the past, but on the legacy of Brown in the present. To understand that legacy, we must take stock of the condition public schools are in today. We're here because non-white school districts receive $23 billion less than majority white districts. Simply put, we're here because the promise of Brown goes unfulfilled. But you all came here today because you have hope for the future, because many of you are actively working toward the goals Brown had envisioned for this country. And our hope is that together, in this room, we can chart a new course forward to achieve the equal, quality public education envisioned by Brown. Now, we're going to hear from someone who spent her life fighting for that future and stands at the forefront of this work. It's my true honor to introduce LDF's Associate Director Counsel, Tona Boyd. Now, so Tona Boyd is the Associate Director Counsel at LDF. Tona joined LDF in January of 2023, and prior to that served as a special counsel and special assistant to the president in the White House counsel's office in the Biden and Harris administration. As a senior member of the judicial nominations team, Tona supported the selection, preparation, and confirmation of federal judicial nominees, including D.C. Circuit and now Supreme Court Justice Ketanji Brown Jackson, as well as the full state of the United States Sentencing Commission appointees. Tona also previously served as chief counsel and senior legal advisor to U.S. Senator Cory Booker on the Senate Judiciary Committee and as a federal civil rights prosecutor in the U.S. Department of Justice. So now please join me in welcoming Tona Boyd.
Good morning, everyone. Thank you so much, Anthony, for that introduction. As he said, my name is Tona Boyd, and I'm the Associate Director Counsel at the Legal Defense Fund. I want to welcome each of you as we begin today's program with all deliberate speed, the past, present, and future of racial equity in education. Before we begin, I want to thank our co-host at Columbia University Law School and Brown's Promise, as well as the staff from the Legal Defense Fund for the tremendous work to organize today's program. And thank all of you for joining us both in person as well as virtually on our live stream as we kick off our very first program to honor and celebrate the 70th anniversary of Brown versus Board of Education. In convening today, we will commemorate this historic ruling while renewing our shared commitment to the ongoing fight for educational equity. More than 70 years ago, community members, grassroots organizers, and lawyers, including LDF's founder and later Supreme Court Justice Thurgood Marshall, along with LDF lawyers Constance Baker Motley, Robert Carter, and Jack Greenberg, fought to fulfill a transformative vision for America. Their shared determination, resilience, and resolve to realize the promise of the words etched into the facade of the Supreme Court, equal justice under law, birthed the strategy that led to the case we celebrate today. Issued on May 17, 1954, the decision in Brown versus Board of Education dismantled the legal foundation of segregation in public schools, declaring that separate educational facilities are inherently unequal. 1 year later, in 1955, the court issued a second ruling, known as Brown 2, that ordered school systems to desegregate with all deliberate speed. Yet while Brown versus Board represented a significant victory in the fight against segregation, its promise of equality has yet to be fully realized. Disparities in access to educational resources, opportunities, and outcomes persist and disproportionately impact students of color and underserved communities. As we reflect on the legacy of Brown today, we must both consider its far-reaching impact and effect while acknowledging that the work of achieving true educational equity is far from over. The goal of today's agenda is to examine the legacy of Brown through robust discussions involving a diverse array of voices, including influential civil rights leaders, advocates, and organizers. We will reflect on the impact of Brown and issue a charge to fulfill its promise. For those of you here in the audience, we invite you to join our closed strategy sessions following the panels, where we will create space to envision a more equitable future, and we'll close out the day with a reception. As we embark on this work together today, I'm inspired by the immense power that lies in our collective effort and shared purpose. Each of you brings a unique perspective, expertise, and commitment to the table, enriching our discussions and propelling us towards solutions. As Thurgood Marshall once said, "I wish I could say that racism and prejudice were only distant memories. We must dissent from indifference. We must dissent from apathy. We must dissent from the fear, the hatred, the mistrust. We must dissent because America can do better, because America has no choice but to do better. So let us strategize today about how we can and will do better." It is now my honor to introduce an advocate and leader in the fight for educational equity and equality. Ari Amenikon is a co-founder of Brown's Promise, an exciting new organization that uses research, litigation, and advocacy to collaborate and advance the educational needs of a multiracial and multi-ethnic society. So please join me in welcoming Ari.
Good morning. Thank you, Tona, so much. We are so happy to be here with all of you, with LDF, with Columbia Law School, and mostly with these amazing people and minds and leaders. This spring, obviously, marks 70th anniversary of Brown v. Board of Education. It also marks 1 year since Saba, Beretta, and I launched Brown's Promise, a new organization that is housed at the Southern Education Foundation. And we have been reflecting a bit lately on what it means that 70 years later, it actually still makes any sense to have a new effort, a new organization, a new initiative, that we need a new effort called Brown's Promise. But clearly we do. Here we are, 70 years later. We still have leaders drawing and maintaining school district lines that segregate children from one another and that facilitate the hoarding of resources into wealthier, wider school districts all too often around the country. I personally come to Brown's Promise and come to this work from a sort of particular vantage point. I have been doing school funding work in particular for the last 10 plus years. I have been a researcher who studies school funding. I've been a policy maker who helps to make school funding policy in the Obama administration. I've been a policy implementer at the Maryland State Department of Education. I've been an advocate at the Education Trust, where we worked very closely with advocates around the country to advocate for better, more equitable school funding policy. I say all that just to say I think it is fair to say that I'm fully a school funding person, and any day of my life that I spend advocating for more money for schools and districts that serve high concentrations of students of color or students from low-income backgrounds is a very good day for me. And I have come to believe that we school funding people are really, really missing the boat if we don't also start to think about the policies, the boundaries, the lines that we draw and maintain that create those concentrations of poverty and that racial isolation in the first place. We aren't going to get where we're trying to go through funding equity alone. It is an important part of the conversation, undoubtedly. But next time you are asked in this work or at a party, why can't we just fund our way to resource equity? It's a common question, right? Maybe only at the parties that I go to, but it is in fact a question that we get asked in work a lot. And so humans, I think in threes. So here are my 3 reasons that we are not going to ever get to where we're trying to go if we are only focused on school funding. The first is that it is wildly expensive to fund high concentrations of students living in poverty. And we all know in today's reality and budget realities that it matters a lot. It costs, according to research, 2 to 3 times as much per student to provide the kind of equal educational opportunities that we want for our children in schools and districts serving high concentrations of students living in poverty. Second, it would require far more redistribution of funds than is politically feasible in our current setup. The school districts that serve primarily students living in poverty, which we all know are all too often also school districts serving students of color primarily, do not elect enough officials, do not send enough officials to their state legislative bodies to make the electoral math add up, to spend 2 to 3 times as much money in those school districts as compared to others. And then finally, and I think most importantly in my list of reasons, is we know that even when we make good progress in school funding reform, we don't get to the kind of educational equity we actually want, not because money doesn't matter, it matters tremendously, but because we know that even in places where school funding is getting better, schools with high concentrations of Black students and Latino students still too often over-rely on novice teachers, overuse exclusionary discipline, and under-provide advanced coursework. And that's the kind of thing that we have to care about. If we're honest with ourselves, we have to care about money and we have to care about those other student experiences. So those are my sort of 3 reasons why 100% I'm on board for school funding reform. And if we're serious about getting to school funding reform, we have to also be talking about segregation and integration. And frankly, on top of that, even if we could fund separate but equal, there's no way that that prepares students for a multicultural, multiracial society that we all are trying to build together and collectively improve. And so I think it is quite obvious that the lawyers who were working at LDF at the time of Brown were very clear-eyed that we needed to do both, that we can't pick between integration and resource equity. We've always got to be doing both. And so we are so excited at Brown's Promise to be able to be here with you all. That was a long way of saying that I cannot wait to spend the rest of the day with you learning from these panelists and these speakers. And I'm going to do a quick overview of the day. Can you all see the overview of the day? Is their agenda up? Can someone put the agenda up? We're gonna start by telling you that you can see more information about all of our amazing speakers if you scan the QR code on your postcard that is on your chair. These are all incredible folks, and we could spend all day giving you speaker bios, and that would be boring, so we're not gonna do that. But you can get more information if you scan the QR code on your card. So we're about to jump into our first 2 panels of the day. The first one is focused on grounding us in Brown's legacy, and the second is taking a deep dive into the new 14th Amendment. We'll close out our morning program with a more sort of intimate conversation, a fireside chat, if you will, with about the next 70 years of educational equity work, which features LDF President and Director Counsel Janae Nelson, as well as my better half, the co-founder of Brown's Promise, Saba Beretta, and Bennett Lunn, a 2L student here at Columbia Law School. We will take a quick lunch break and come back for a panel discussion on intergenerational movement lawyering, which will feature students and the adult lawyers who are working with them. Tona will be back to close us out, and that will conclude the open press portion of the day. If you are here in person, we certainly invite you to stay with us for 2 closed press breakout sessions on non-legal strategies that are also critical in this work, one focused on policy strategies and one focused on applied research. And once we have made it through all that, we're all gonna need a drink or a few drinks, so come back here for our reception that was so generously sponsored by the Eric Holder Initiative for Civil and Political Rights. All right, you guys, we can't drink yet. It's only 9:30, so I'm going to do a very quick set of introductions. I'm going to ask if our first set of panelists, our first panel could join me on stage so that I can give you a brief introduction. All right, great. So our moderator today is Professor Jadel George, who runs the Racial Equity in Education Law and Policy Clinic at Georgetown Law and is a former LDF attorney. Our panelists are Floyd McKissick Jr., whose father, Floyd McKissick, was an LDF client before Brown, working to integrate UNC law, and who, in his own right, has been a state senator in North Carolina, a professor at Duke University, and an attorney in private practice, as well as a commissioner right now today. So we are deeply honored to have him here with us. Professor Olatunde Johnson, a Ruth Bader Ginsburg Professor of Law at Columbia Law School, also a former LDF litigator. Sam Spittal, today's Director of Litigation and General Counsel at LDF. Raymond Pierce, President and CEO of the Southern Education Foundation and former LDF cooperating attorney. You are sensing a pattern here. And Malik Sammons, a current 2L at Columbia Law School and, you guessed it, former legal extern at LDF. So we are thrilled to have them here. Please join me in giving them a round of applause.
I think this is on, right? Well, thank you all so much for joining us this morning, particularly the law students and undergrads, because I know how painful this is. We're actually going to we're going to look a little bit before Brown versus Board of Education. So we're going to look backwards before the 1954 ruling, and I am going to turn to you, Mr. McKissick, and ask you to take us back a little bit, right? So the efforts to dismantle Jim Crow really started in the higher education space, right? And so can you take us to the time where your father, who had graduated from Morehouse College, who had come out of the Army, was working with Thurgood Marshall and the other attorneys at the NAACP Legal Defense and Educational Fund, or LDF as we'll call it throughout the day, to integrate the University of North Carolina School of Law. He went on to become the lead plaintiff in the case McKissick versus Carmichael, which was eventually decided in 1951. The court sided with the plaintiffs and mandated this desegregation of UNC School of Law. But can you take us to that time? What stories do you remember your father telling you about that time?
Well, if I think back about that time and the way my father saw it, he had fought in World War II. He viewed it as a war against racism because of the issues that were involved, the way the Jews were being, basically taken out over in Europe, and of course, understanding the battles that were being fought in World War II, and then seeing President Truman come in and basically integrate the military around 1948 or so, he really felt as if it was important that African Americans have access to higher education. I mean, you had the GI Bill of Rights that was providing educational opportunities, and he had begun his legal education at North Carolina College, now known as North Carolina Central University, at the law school there, and felt as if getting access to UNC's law school was imperative. That, you know, there wasn't anything that was really equal about being separate. I mean, the facilities were totally inadequate at NCCU, a number of books in the libraries, the facilities themselves in terms of their adequacy that they provided students, the number of persons that were on staff. So he really felt as if it was important at that day point in time to really be actively engaged in tearing down those barriers of discrimination. Of course, Thurgood Marshall was the one that represented him in that case, and of course they did prevail. Most people believe that he got his law degree from UNC. He didn't. He got his law degree from North Carolina Central University. And the reason being, they would not accept his transfer hours, and he would not want to repeat all of law school by the time that case was litigated. So, but he always been a very seriously committed to addressing those inequities in education, and later went on working with the Legal Defense Fund to desegregate the undergraduate school at UNC, and fought additional battles in North Carolina on behalf of my sisters to integrate Durham city schools, which followed Brown in 1959 when they first integrated the schools in Durham.
Wow, wow. And you, of course, went on to Duke Law and to graduate from there. If your father, what do you think he would want us to know or remember today as we're looking back 70 years after Brown, even more years since he waged his battle against Jim Crow education? What would he want us to remember?
I think he would want us to be vigilant and want us to remain steadfast and determined and understand that regardless of the landscape of the courts, it's important to get out there and do what is necessary, whether it's litigation, whether it is protests, or in his case, you know, he later became the leader of the Congress of Racial Equality, which back in the 60s was really the second largest civil rights organization in America. It had over 240 chapters in something like 43 different states. So, I mean, he was actively engaged not only in tearing down barriers to discrimination in education, but across all barriers, whether it's public accommodations, you name it. But more importantly, he believed that it was necessary to be vigilant when it came to political change and making certain that people became involved in the political process, that they went out there and voted on a regular, consistent basis. I think he would be very disappointed to the extent to which access has been provided today to educational opportunities and, more importantly, to the political process, but to see the complacency in people not getting out and voting the way they should and the way they need to, because right now we wouldn't have the imbalance that we have on the U.S. Supreme Court had it not been for what occurred in the 2016 election cycle. And if people had gotten out and voted differently, we wouldn't have seen the appointments to the Supreme Court that came about with Trump. And more importantly, I mean, I think similar types of battles are being fought throughout the 50 states.
Absolutely, absolutely. So key takeaway, young folks, be vigilant. Stay vigilant. In these battles, the battles to secure voting rights, to sustain voting rights, the battles for public education, these are all interrelated. Professor Johnson, I'm going to turn to you a little bit as we move from higher education to the K through 12 space. What was prompting, and again, we're thinking around pre and at the time of Brown, what was prompting the urgency for the school desegregation cases, and what was the vision of success at that time?
Yeah. So first of all, it's nice to see so many familiar faces and new faces as we talk about these issues. One of the things that makes me most excited about this day is actually that it was organized by students. I think it's sometimes hard to convey the urgency and the contemporary importance of this issue, and students are seeing it themselves. I think in some ways, having been, this is billed as a multi-generational panel, I didn't want to inquire too much as to what generation I was being cast into.
I just assumed that the emerging.
It's not the law student generation, but I've sat at a lot of Brown anniversaries. It's also the 60th anniversary of Milliken v. Bradley this year. And I think what happens at a lot of these anniversaries is we talk about the incomplete work that needs to be done and how, there's more work to be done. This year, it feels more auspicious even because we're seeing in real time a co-optation or weaponization of Brown to ends that seem to me directly in conflict with what promoted and created the urgency that you are talking about. So I'll say briefly, so what's the example of that and what am I thinking about? Of course, is the SFFA versus Harvard case, where I recently counted for an article how many times Brown was cited, and it's over 80 times by the dissent and the majority, and of course to completely different visions, and I'm sure we'll come to that in the discussion. So even starting before Brown, you think about, you look at the 19th century cases that were brought to desegregate segregation, and one of the earliest cases was brought by Charles Sumner, who was one of the drafters, the radical Republicans who drafted the 13th, 14th, 15th Amendment, and then Robert Morrison, who was one of the nation's first black attorneys, and this is in Massachusetts, which had a common school law. But what they identified as the core of what they were fighting for is very much in conversation with and was explicitly invoked in cases like Sweat v. Painter in the lead up to Brown, which is the notion of equal citizenship, anti-caste. I think that is the core notion that was being fought for. Of course, at the time, the attack was on laws that formally distinguished on the basis of race, right? And so the invocation in these cases was that you're setting up a caste system. In these early cases, even comparing it to, we've already talked about what was happening in Europe, treatment of Jews, creation of ghettos, invocation of India's rigid caste system. And so the promise of Brown, and especially in the wake of the 14th Amendment, was that the 14th Amendment was putting forward an equal citizenship principle, and in the sort of, short story, long story, we'll talk about the different kind of contestations over Brown, but the idea and the vision of success was that you were going to remove these formal barriers in law that created an impediment to equal citizenship, but it went beyond just the idea of formal equal citizenship. It was actual equal citizenship, so destigmatization and caste. And then education was not just incidental to that. There are lots of areas where you could think about vindicating that principle, but education is core, as you see this language in Brown, core and fundamental in a democracy. So there was a strategy around that. Now, I don't know if you want to get into there have always been divisions about how much emphasis to put on desegregation and integration versus resource equity. That was there from the start, and I think it lingers on actually as part of the legacy of Brown too.
Thank you for that. So I'm going to mix it up a little bit, students. Okay, so I want to talk a little bit about implementation, but also resistance to that implementation, right? Critical race theorist Kimberly Crenshaw talks about we have these moments of racial progress that are followed by backlash or retrenchment. So we know that implementation of the Brown ruling was slow, that in 1955, in Brown 2, which no one really talks about, the court asked districts to desegregate with all deliberate speed. But what did that really mean? And so I'm actually going to turn to Mr. Pierce and ask you that. What are your thoughts about that resistance? And now we know it is massive resistance, which spanned well over a decade. But just that resistance to the ruling.
Thank you, Professor. The resistance has never gone away, and it's somewhat understandable, but if you will allow me, I've got to follow up on something that Senator McKissick said. Senator McKissick's father was a graduate of the law school where eventually I became dean of North Carolina Central University School of Law, which at one time the chancellor was Julius Chambers, who was director counsel for the Legal Defense Fund here at the NAACP. So it's a small world, folks. But one other point in that, talk about resistance. For years, decades, black folks were applying to the University of North Carolina, Chapel Hill, and constantly being denied to the point where the state said, okay, we'll give you a colored law school. And they created the Central's Law School for colored folks. And they put the dean of the law school at Chapel Hill was supposed to preside over both, but he never came and visited the campus. And no classes being taught. It was the white professors at Duke University that said, okay, and they went across town and got the law school started. There was always resistance. And every year, black graduates of that law school were suing and suing and suing. Floyd's father was one of them. And the response by the state was, instead of allowing black folks to attend the Chapel Hills Law School, we'll just put a few more dollars into the black law school. That's real, folks. That's real. I look at this 70-year mark here. I'm 65 years old. This was 5 years before I was born. Senator McKissick was alive when this happened. All of my cousins attended segregated schools. My mother and father, everybody I know attended segregated schools. This was, to the professor's point, apathy comes, I think, from time. And people think that was a long time ago, when it was not a long time ago. It was really not a long time ago. I'm dealing with my grandfather's land right now. I knew him well. He celebrated me passing the bar exam. He was born in 1885, 20 years after the end of the Civil War. Most everybody he knew in Mississippi had been enslaved. My point, it was not a long time ago. Now, to answer your question, Professor, right out of law school, practicing law in Little Rock, Arkansas, we had the Little Rock school case. And we were working on the Dow versus Oklahoma City school case, which eventually went to the United States Supreme Court. Both of those cases were very interesting in terms of resistance. Here you are in 1984, and the Dow case was all about trying to keep the court order in place. The state was trying to end that court order that had not been in place a long time. And the Little Rock school case, I was a baby lawyer right out of law school, 1984. The Little Rock school case, which had been in court forever, was now to the point where it got to the point where we were talking school consolidation to consolidate the school districts around the city of Little Rock, Pulaski County, North Little Rock, and Little Rock School District because of the resistance. The resistance has never gone away because there has always been this sentiment that educating black folks is a waste of money. Have you ever heard that before? It's historic, people. And there's a reason for that. The denial of education was a critical tool for enslavement. Denial of education became a critical tool for segregation. And so those sentiments don't die easy. So I'm not surprised that we still have resistance to this day.
Absolutely. Thank you. Mr. McKissick, yes, please.
Yeah, just to comment a little bit on that. I mean, if you look immediately after the Supreme Court decision in 1954 in North Carolina, specifically in Durham community where I live and where North Carolina Central University is located, I mean, you had the city school board sit back and come up with reassignment plans that basically were theoretically to implement the Brown decision. In reality, it was just the reverse, okay? Because what they would do is establish school attendance zones that kept black kids in black schools and white kids in white schools. And they continued doing it, and they would give you the assignments for that particular year. If school was beginning, say, the last week of August, they'd send out those assignments the week before. And then you'd say, well, you can protest it, and you can go through administrative processes and procedures to do it, but if you went along that pathway, you were not going to be in another school that year. And it went on for ad nauseum for many, many years. I know my father filed a lawsuit on behalf of my mother and for my two oldest siblings, and basically with the goal of making certain that they could have access to the local schools there in Durham. And there were other plaintiffs that were part of that. They brought it initially as a class action. Ultimately, by the time it was resolved, it applied only to the people that were involved in that case, as opposed to class action, and they were able to get in the fall of 1959. So, I mean, systematically, there was that type of discrimination that continued to occur, and they would come up with really resourceful reasons to deny the reassignment. They'd say, well, you know, it's going to be a hardship on the 1,200 students at the White High School to see a couple of African Americans come in. Understand as well that at the white schools there were restroom facilities, but restroom facilities were not integrated at that time. They really didn't want black kids using the restroom facilities either. They didn't want black kids swimming in swimming pools. They did not want any of that to occur, so they come up with a pretext. You know, in that particular case, when my parents argued why my sister should be assigned to the White High School, it was geographically closer. It was a 1.5 miles away. The black school was 2.5 miles away. But they still would come up with pretexts for not allowing it to go forward. And it wasn't until there was decisions rendered that would have made it possible for that relief to be granted to integrate the schools that you see the school board going ahead and acting as it should have from the outset to integrate schools in Durham. But were there efforts made like that across the South? The answer is absolutely yes. I mean, it was a denial of the remedy that Brown represented, and they would even go as far as to say Brown might have said that you must desegregate schools, but it did not require you to integrate them.
Right. So it's interesting just how this resistance evolves and shape shifts over time, and we see during that period of massive resistance the evolution of these other schemes, whether it was privatization or vouchers or what you were referencing called pupil placement boards, where they would say, oh, we're just giving parents a preference or choice, but then assigning students in discriminatory ways. So many of those kind of tactics have their origins during that period of massive resistance. And I think it was Virginia Senator Harry Byrd who said, as long as we can legislate, we can segregate. And they found many ways throughout the South to do that. But again, to your point, your father's message about remaining vigilant, black people continued the fight and fought for access to education, and it took a long time, but eventually a lot of progress was made towards school integration. So if we look back, where it's only about 1% of black children in the South attended schools with white children in 1963, that's almost a decade after the ruling. Approximately 90% of black children attended desegregated schools in the early 1970s. So the work continued, the push continued. Professor Johnson, can you highlight some of the key impacts for both students and educators? And a lot of people don't talk about the impact of Brown and desegregation on black educators, right? So there were obviously, and we're not here today to question the validity of Brown. It is a monumental, necessary ruling, but what were some of those impacts, both good and bad?
So I can't resist going back to your question about with all deliberate speed, because I was really curious in some ways about that as a title and a framework for today. I think it's really interesting because it focuses us on something that Senator McKissick said, which is about remedy as being central. Like, if I think about part of the half-full, half-empty legacy of Brown is like a deep unseriousness about remedy. There's always a narrative, and I think it's already been picked up in the stories that have been recounted, which are one that it's just too much time. As like we've done this as a formal matter, but now it's time to get rid of these remedies, right? And so you see that in sort of the move towards declaring all these schools unitary, but then also a concern about harm to white people, like you're inconveniencing them. You know, you think about all those sort of challenges to the remedy, a lot of them are about this sort of idea of innocence. So like we're gonna have to inconvenience ourselves in some ways and restructure things in some ways to really fulfill the legacy of Brown. So you highlighted, and I'll just say this very quickly because I know I want to get Sam and Malik into this discussion, that a big push in the area of desegregation and integration, you can't neglect the role of the federal government. And there wouldn't have been as much progress made if you didn't have Title VI of the 1964 Civil Rights Act. And I think it's always important to remember that, especially those of you who are lawyers, that the federal courts could only do so much. You also needed Congress and administrative agencies. And that's particularly crucial to think of this at this point where Congress doesn't do as much as we want it to do in terms of legislation. And also there's an attack on the administrative state. But you need funding, and you need funding support in order to advance this work. So that's going to be a key lever point when we think about policy solutions. In terms of the mixed legacy, I remember really exploring this with Amy Stewart Wells, who is at, I think it's still at Teachers College, I believe, and did a lot of the briefs on the K through 12 kind of empirical briefs for parents involved. And she does a lot of work, and she used to do a lot of work on the long-term success of school desegregation cases. People never used to look at that. In fact, they thought that the cases were unsuccessful for Black students because test scores didn't immediately go up. But when you look at the long-term benefits, you see all sorts of long-term benefits in terms of income, what people call social capital, the ability to deploy a diverse set of networks. Now, I don't think those are the only reasons to urge integration. I think we need, integration should just be fundamental in a multiracial democracy. But you see these impacts short and long term. So I'd ask her, well, why didn't you see the immediate impacts? And schools are very disorganized. In the wake of school desegregation, there's a lot of tracking, which is something we still have to keep an eye on. And then, as you're alluding to, and here I'll end, and we can explore more, but there was a tremendous impact on Black teachers, and that's become a real focus of advocates today. I know National Coalition on School Diversity, which is represented here today, is thinking a lot about the immediate impact. I mean, when people trace the impact, there are different figures that are offered, anywhere from 25,000 to 100,000 teachers lost to the system in a way that hasn't been recovered today. And there's a lot of empirical evidence on the impact of Black teachers on all students, but also on achievement of Black students specifically. So we're still living with that legacy. And that was part of why there was conflict, I think, over in some places like Atlanta, over whether or not to really follow up with the Brown's remedies, because they felt this kind of impact on its effect on Black community schools and these Black professional networks that were so important for Black student success.
Thank you so much for that. And transitioning to Mr. Spittal to talk a little bit about the legal strategy. What was the legal response to addressing this massive resistance?
Yeah, so I think this is to follow up on Professor Johnson's framework as the legacy of Brown in the courts is a legacy of deeply unserious remedies. I love that phrase. It's very sad how true it is. There was, however, one moment where I think the Supreme Court was serious about remedies, and that was in the late 1960s. And I would say that building on the work of the litigators who continued to push cases, especially in the 1960s, and that was when the Supreme Court decided a case, Green versus New County School Board. And the specific issue in Green was about the validity of a school choice remedy, a purported freedom of choice plan where parents could sort of choose where to send their children to school, and whether that was an adequate remedy to address the harms caused by decades, centuries of state-sponsored de jure segregation. And the Supreme Court answered that question, no. But what was so, I think, important about the decision were a few things. First of all, and to sort of get to the earlier conversation also about, what is Brown really about? Is it about integration? Is it about resource equity? The Supreme Court said, we have been talking, or many people have been talking about Brown as about integration. And yes, that was the immediate issue in many of the cases. And I think notably, they also talked about the courageous Black students who sort of bore the brunt of that initial wave of integration. But the court in Green said, no, Brown is really about something different. It is about fundamentally eradicating discrimination in education. And that is, yes, student assignment is one part of that, but we're talking about all facets of K through 12 education. So that means discrimination in faculty and staff hiring. It means discrimination in transportation, access to transportation, discrimination in facilities, discrimination in extracurricular activities, and as the decision has been interpreted over time, discrimination in quality of education. So this was a moment where the Supreme Court also said, we are done with all deliberate speed. It has been long enough, and we're actually taking these things seriously, and it is incumbent upon school districts to address all of these facets of persisting discrimination, persisting caste systems in K through 12 education, and to do so now. So this was the one moment where, from a litigation perspective and complementing the work of the federal government that Professor Johnson talked about and the impact of Title VI, you actually saw a real impact in terms of Brown's promise making actual progress, particularly in southern jurisdictions in the late 1960s and early 1970s, as the statistics you cited indicated. There was, of course, though, a resistance to that temporarily moment of serious remedies, and there was a change in the political environment. President Nixon won the election and dramatically shifted the balance of power in the Supreme Court, which led to the very notorious decision in Milliken versus Bradley that Professor Johnson talked about in 1974, where the Supreme Court held that even when the state was, by all parties' recognition, responsible for the segregation of Detroit schools, and even though the boundaries of school districts are totally set by the state, and even though the state had facilitated segregation, and I use that word to really mean discrimination, because again, we're not just talking about student assignment, a tremendous disparity in resource allocation between schools in Detroit and schools in surrounding suburbs, unless there was very specific evidence that the suburban districts themselves had been responsible for that discrimination, that segregation, there could not be a remedy that would cross district lines. So that was a tremendous limitation on the progress and the promise that the court had made just a few years earlier in Green, because especially in northern and midwestern districts, it was really necessary to have an inter-district remedy to have the kind of meaningful relief from discrimination that the court had promised in Brown and then in Green.
Pierce, do you want to add anything to that, to this kind of evolution? You talked about the cases that you worked on in the 80s, but that continued or evolving retrenchment.
Well, yes, here's my reflection. That was just an excellent analogy of jurisprudence on school desegregation. So I appreciate that. But it may raise a major point that I have felt for many, many, many years, and now in my role, I have to state, this is not, this meaning solving this issue, genuinely addressing this issue of access to quality education, competitive education, is not simply a legal issue. It is not. I personally believe that because it was left as a legal issue, we didn't achieve as much as we needed to achieve in this. And so let me put this in a context. There was a strategy for the education of black people coming out of enslavement. There was a strategy. It was education. It was building schools, training teachers, and buying books. That was it. It was largely philanthropic, a little bit military because of the Civil War and the Freedmen's Bureau, if you remember that history. And then during the Reconstruction period, when black people were elected to office in large numbers in the South, their only policy they were pushing for was what? Taxes to pay for these teachers and books and schools that philanthropy was paying for. The Jeans Fund, the Stokes Fund, the Rosenwald Fund, eventually the Carnegies and the Mellons got into it, the Rockefellers got into it, but it was to sustain that, and they won. They set up these structures in South Carolina, North Carolina, Virginia, throughout the entire South, Maryland, wherever there was lawful slavery, there were structures for taxes to pay for teachers, books, and school buildings. But there was always a fight, there was always an effort by white folks, poor white folks actually, to segregate those funds. Taxes from blacks go to support black schools. Taxes for whites go to support white schools. There was always that fight. At the same time, black folks, in line with philanthropy, were working hard to train teachers. All these historically black colleges and universities, McKissick, you know this story, were what originally? Teacher colleges. It was a massive machinery, a massive machinery. It was a policy to put out, train people, to educate these masses of people who had just come out of slavery and their descendants. At the same time, as this segregation settled in, organizations like mine, by the time we got consolidated in 1934, it was working with Charles Hamilton Houston, eventually Thurgood Marshall, and Constance Baker Motley, Mayor McLeod Bethune, some names you might not remember, Benjamin Mays. Those folks were behind the scenes working on challenging the constitutionality of this separate system of education, while at the same time building more teachers, building more schools. When the desegregation case came down, a lot of that, as the professor said, got dismantled. That meaning that machinery of putting out black teachers, of concentrating on black schools, which was being done. We have to be able to do both. We have to be able to walk and chew gum at the same time. I'm so glad Brown's Promises, came into being for this very reason, because there's unfinished work to be done. It is critical work to be done right now. This country is becoming internationally at a competitive disadvantage, and we can address that by addressing this issue.
Absolutely, and thank you for underscoring that significant history. I don't think a lot of folks understand that it was the formerly enslaved black people who really shaped our contemporary U.S. public education system. They were the elected leaders you mentioned, and we did have a lot of black people in Congress went back to their home states. They fought for inclusion in state constitutions of the education provisions, right? Those have become so instrumental and are relied upon in a lot of resource equity litigation, because there was another case in the 70s, unfortunately, 1973 San Antonio versus Rodriguez, in which the court said there's no explicit or implicit constitutional right, federal right to education. And so those very clauses, those state constitutional clauses that so many of the black elected officials fought for have become and remain instrumental in school resource equity litigation. I see Professor Mike Rebell, who's done a lot of that litigation. That has become so instrumental. I want to turn to Malik and talk a little bit about today. So you've heard us talking, Malik, about this history, about what's happened before. I think they're all on. At least I don't have a light on, so I think they're all on.
Yeah.
And so I want to hear from you, Malik. How do you think this has shaped your educational opportunities, right? We've talked about desegregation, what it looks like from all facets, right? The green factors, in-school tracking, these different things that are still happening. How do you think your generation perceives Brown today?
There's many talks about diversity and DEI and how can that actually provide any sort of benefits, but I do believe that being able to hear from the experiences of people from a variety of different cultures, different backgrounds, is something that Brown was looking to achieve. And I think that is something that has been a part in my life that allows for us to experience shared humanity. It allows for us to see how, on an individual level, race can play an important factor, which is such an important factor in so many different people's lives, and how that can manifest in different ways. So I think that being exposed to that is a really beautiful aspect of Brown. And I also just think that the way that Brown has laid the forefront for new ranges of advocacy, so being able to set the message that there's nothing inherent about a person, specifically and especially their race, that precludes them from being able to engage in any sort of opportunity. That has spread to so many places, whether housing and looking at the Fair Housing Act, whether it's trying to be free from pollution, whether it's having access to healthcare. And so I think that Brown has kind of just shaped a lot of the way that we view where people are allowed to be, and that is should not be and cannot be restricted on any sort of manner. I do want to say, though, that I think that my generation is not as rose-colored about how Brown has obviously played out. There are many ways that it has not addressed some of the critical needs that we see within the world. But I think that one of the major problems of that and how Brown impacted my educational experience is that you kind of learn about Brown, you get there, you're like, oh, this is great, you know, Brown has ended it all, segregation is done, you know, we're over. And so I think that there are just so many ways that we need to continue to educate each other. And I think that not having that sort of education has allowed for some sort of apathy within the fight for actually experiencing educational equity. But I would say, though, too, that this is like these dilemmas, these disparities, these are things that we see. These are things that we experience. You know, I grew up on a pretty interesting area in the city where that I'm from, where there's about 4 school districts within 10 minutes of my home, and seeing how those places are broken up along racial lines and how they can be so racially different within such a very small geographical area is just disheartening and very heartbreaking. So I think that we know of these sort of things. We know that we are allowed to be in these spaces, and I think that now our goal for Brown, again, speaking for myself, but I think that a lot of people that I've interacted with in my generation are looking to push the needle towards addressing some of the more systemic issues in the interdisciplinary areas in which Brown sort of bleeds into in our daily lives.
Okay, I'm going to add in a little question, Malik. But what drove you to just your interest? I know you had a large role in shaping this event, but you also did an externship with the Legal Defense Fund. What do you think has really fueled your interest in these issues?
Yeah, I think that, like I had mentioned, just kind of some of my own background in seeing the disparities. There's so much that I guess kind of happens in our lives. But especially as a young person and without this access to being educated a lot of times on all of the ways that racial discrimination is continually perpetuated on a systemic level, it can seem a little bit like a fishbowl until you are exposed to these issues. So you're just kind of living your life and going about your day because this is what is taught, and these are the sort of, there are all these holes within our information that we are receiving. But I think that once I was able to have that sort of exposure, that these needs are indeed manufactured, and that the problems that we face are indeed manufactured. I think that that put an intrinsic motivation in me, especially seeing some of the ways that these disparities have had played out in my life, in the lives of my friends, people that I had interacted with. So I think that personal experience is really motivating, but also it at this point seems to be slightly a cliche, but the people who have been in the seats before my generation are just so monumental in allowing for me to be in this position. And so I think that seeing the fight that people have gone through, the ways in which they have sacrificed so many just hard things to let go of, I just feel like that their legacy, their efforts just have to be respected and uplifted within the fight of young people and within this next generation.
Absolutely. Thank you for that. Going back to Mr. Spital, can you tell us more about the work that LDF is doing today? Whether it's your desegregation work that you're doing to address the battles that are being waged today to continue the work of fulfilling Brown's promise.
Yeah, let me start by sort of noting and acknowledging that litigation is clearly not the only solution to these problems, and it does have to be seen as one tool in a much larger toolbox for so many reasons. I think that to the sort of point about apathy and Brown seeming so long ago, and well, this is whether you see it as a moment of victory or a moment of unfulfilled promise, what I think probably a lot of people don't realize is that there are scores of jurisdictions, primarily in the South, that to this day are under desegregation orders because they have still not complied with Brown. And so as we are sitting here, there are LDF lawyers at trial in Louisiana litigating a case about St. James Parish and its continuing failure to eradicate the vestiges of de jure segregation. And most of the work that LDF is doing today, and when I say LDF, I also should really say the folks who, more than anything, should get the credit for any successes in the litigation are our clients, who to this day continue to be incredibly courageous by being open to acting as class representatives in these cases. While there have been some changes, they continue to face the risk of retaliation from being willing to be part of these cases, and so we really should emphasize them and their work. But for the most part, the kinds of work that we are doing that is building upon Brown and building upon the green factors is not focused on student integration, at least in the sense of integrating buildings. It is focused on things like persisting discriminatory discipline, which is just such a widespread phenomenon, and is something that when there are districts that are still under these desegregation orders, we can challenge in a kind of way that we could not challenge in any other sort of district because of the legacy of Brown and of Green from just sort of a litigation perspective. So just last year, we had significant victory in St. Martin Parish, Louisiana, focused largely on these issues of discriminatory discipline, discriminatory access to advanced placement courses. Other ways in which the work continues to really matter is when jurisdictions have to close schools and consolidate, they have to do so if they are pursuant to these orders in a way where Black students do not bear the disproportionate brunt. So I see some members of our Chambers County, Alabama team here in the audience. They were instrumental in ensuring that Black students, a predominantly Black school would not be closed until a new high school would be built that would be consolidated for all students in the district. And what the district had wanted to do was to close the predominantly Black school and force all the Black students to go way to the other side of the county in a very racially hostile school. And we were able to defeat that effort because of Brown and Green and the legacy. During COVID, one of the issues that I'm most proud of LDF's work, and again, when I say LDF and our clients, was pushing to ensure that remote instruction, access to meals would be done in an equitable way. And we had so much leverage that we would never have had if it weren't for Brown and Green. But then, sort of also acknowledging the limitations, because of Milliken, we have also had to look in other directions and to state court litigation to try to have, at times, more robust remedies. So the great Dennis Parker is here, and because of his work and the work of so many others over the years, there's this case, Sheff versus O'Neill in Connecticut, where as a result of state constitutional litigation building upon Brown, there actually has been an inter-district remedy in both Hartford and the surrounding schools. So that's really all to say that, if you're interested, especially for the students, if you're interested in doing civil rights law, Brown is not only about a legacy in a very concrete way. I mean, Brown and Green are the cases that we continue to rely on in our education work in really a daily basis.
Thank you so much, and thank you for just emphasizing too that there are so many different tools, right? There's definitely litigation, there's organizing. LDF has an organizing arm that has always been very active. There's policy work that's really instrumental to Professor Johnson's point about the federal government. It's also state and local governments, having folks on the ground in the states. Mr. Pierce, speaking of the South and given the ongoing resistance in the South, can you talk about the work that the Southern Education Foundation is doing? You mentioned Brown's Promise work, but can you tell us a little bit more about that work today?
Well, yes, Professor. One of the things that I was approached with about 3 years ago, and this goes back to a comment the professor made about the federal government. In 1964 Civil Rights Act, there was a pot of money that was set aside, was created actually, to create something called desegregation assistance centers. I'm sure the great Dennis Parker remembers those. When I served in the Clinton administration at the Office for Civil Rights, they were called desegregation assistance centers, and they were designed to assist school districts struggling with school desegregation and provide technical assistance to work their way through it, as opposed to going back to court over and over again. Well, the name was changed to Equity Assistance Centers about 10, 15 years ago. We were asked to apply for the grant from the federal government to manage the Equity Assistance Center for the South. I thought about it, I figured government money, maybe leave it alone. Actually, I found our history that the Southern Education Foundation actually lobbied to get that money back in 1964 as in the aftermath of Brown versus Board of Education. We applied, we got the grant. So we now run the Equity Assistance Center for the South. And as you said, Professor, Counselor, the bulk of those desegregation cases are there. That's what made me do it. When I realized, and I talked to Sherilyn Ifill about that. I saw her walk in here. I talked to her about that before I did that. And I said, yeah, there she is. And you may remember that, Sherilyn. I said, should I go for that? And we did it. We've got it now. And I really want to prove to the Department of Education, the United States Department of Education, that those funds can be used far more strategically if they're used collaboratively, as opposed to just sitting back and off to off. You got to work with the attorneys, work with the teachers, work with the teachers' unions, work with the superintendents' unions and associations to find out what is the best formula we can put together to increase the level of quality education for our children. So that's one way. Second, one of the oldest programs that the Southern Education Foundation had, which existed even before we were consolidated, was teacher development. And leadership development, developing leaders and developing superintendents. Google up the word Jeans Teachers and Jeans Supervisors, Jeans. Came out of Philadelphia. Anna Jeans, considered one of the wealthiest women in the nation at the time, Quaker woman, made millions of dollars in the insurance business, was a staunch anti-slavery person, ran the abolitionist movement, bankrolled Frederick Douglass. The Underground Railroad came across her land, which is now Temple University's hospital. All her money on that side came to us. That's the Southern Education Foundation. But that program was designed to create leaders to run these school systems that were being set up after the Civil War. We kind of got out of that for a little while, but we're back in that too. To create leaders to run school districts, to help them understand these racial inequities, because it's hard for superintendents to work on inequities when day to day they're dealing with teacher shortages and all this kind of stuff. Combine that with our Equity Assistance Center work, combine that with the fact that now we have Brown's Promise, and that was another decision. I was so glad Arian Saba came to me with that idea. And I said, okay, bring that into the Southern Education Foundation also. And with a program we have that we brought in from Harvard University, outcomes-based contracting, and I see the director is here, to help school districts use their money more efficiently. We got to do a better job with the money we do have. So the hope is that creating this laboratory at the foundation can come up with better ideas in partnership with our friends, with the Legal Defense Fund, Southern Poverty Law Center, Education Law Center. That's the idea. Hopefully it'll work.
All right. So we are going to wrap up really the way we started, and I'll turn back to Mr. McKissick, and I'll give everyone, let's see, a minute, maybe 25 seconds. If you could say, what do you think, you talked, Mr. McKissick, about what your father what message your father would want us to carry forward from the work that he did. But if you could tell us, what do you think is Brown's legacy today, and what do you hope it will be by the time we get to the 100th anniversary? So we'll start with you, we'll go back here, and then we'll go over.
I think Brown's legacy today is the opening of pathways of opportunity for students like Malik and many others to have access in ways that they never did before. I integrated public schools at the 6th grade level. And when I went there, they'd pull out a copy of World Book Encyclopedia, and they would sit there and look at the evolution of man. And they'd say, well, this is where apes were, and this is where white men are, and this is where blacks are, somewhere in between. They thought you literally were inherently unequal and inferior in every respect. Everything you said and did was establishing a mindset, not just for the students in that classroom and for the teachers who were seeing black students for the first time, but you were making an impression for your entire race. And I guarantee you, if you took a poll of everybody in that 6th grade, and you would say, who among you one day will go on and get graduate degrees from Harvard and Duke and University of North Carolina at Chapel Hill, who work with some of the large law firms in our nation's capital, with some major clients, If you'd ask them who will go on to serve on city council in Durham, who would go on to serve in the state senate for 13 plus years, who will pass expunction laws that will impact the lives of people to give them a second chance, who will sit there and vote to make certain that when it came to early voting, that it was extended to 7:30 in the evening to give people the right to vote, or be able to make certain that you had other barriers torn down that limited access to the voting booth. If you ask a series of questions about who within that sixth grade class might be able to do it, nobody would have picked me. But yet I'm the only one who did. And that's why that pathway of opportunity, has to be open for all, regardless of their race, regardless of their religion, regardless of their sexual orientation or their gender identity. It has to be open for all, regardless of what bridge they cross to get here or what border they cross to get here. It's about epitomizing what America has to offer and opening up access to the American dream so that everybody is included. That's what Brown, in my mind, epitomized. That's what Brown's legacy should be about. And that's what we have to remember and understand. The same way the pendulum of time can swing forward, it can also swing backward. And to be able to fight vigorously and aggressively against the powers to be and understand the judicial system is inextricably linked with the political system. And all those resources that need to be allocated to make facilities equal are made by political leaders. And understanding that you have power at the ballot box. Understand that you have a right, not just in the courtroom to demand equality, but you have a right every voting cycle of every year to go out there and elect good people who will carry out policies that will open up those doorways of opportunity for all and to provide the type of equity that is absolutely essential and which, in my mind, Brown epitomized. That, in my mind, is what it's all about. That, I hope, when the 100th anniversary comes around, we can at least see more progress being made. I don't want to see what occurred after the Reconstruction period. Dean Pierce here talked about, African Americans getting elected to Congress. Yeah, in North Carolina, we had over 4 congressmen elected between the end of the Civil War and 1901. But you know what? Because of the Supreme Court decisions that occurred and policies that were implemented, we didn't see another person elected for 90 years. Mel White and Eva Clayton got elected. It had taken so long that African Americans, everybody else, thought they were deferred blacks elected to Congress from North Carolina. We cannot sit back. We cannot get complacent. We have to be forever vigilant and committed to continuing the progress and not allow our country to regress. We have to be the moral compass.
Yeah.
Thank you. Thank you.
Well, I don't really want to follow that because I'm certainly not going to be able to say anything as significant or powerful. I think, for me, Brown's legacy today is very mixed, to be honest. And the thing that really, I guess, I think about when you ask the question is, you may remember that during the Trump administration, there were all these judges who all of a sudden would not say that they thought Brown was correctly decided. And one of our responses as LDF was like, even Justice Alito said Brown was correctly decided, which I think was the right thing to do as an advocacy moment, but it's a little bit tricky because he is saying Brown is correctly decided, but then weaponizing it for the opposite meaning. So when it has such acceptance to become almost meaningless because it can be weaponized by forces of racism, in a case like SFFA, you realize that Brown has lost much of what it actually is supposed to be about, at least in popular consciousness. What I hope for Brown's legacy to be, at 100 is exactly what Senator McKissick said. And I think that for that to happen, we need to be very clear and honest about what Brown is actually about. And I do think that part of that is also recognizing that it can't just be about sort of lawyers and the legal aspects of the decision, that we have to recognize that Brown is about a commitment to a multiracial democracy premised on equal citizenship where power is shared. And that is what Brown is about, and that is a principle that is beyond sort of litigation purposes, and it's a much broader statement about a commitment to our multiracial democracy.
Yeah, I won't reiterate too much, but I think that for me, Brown is definitely just about saying that there's nothing inherent about who somebody is that should govern where they're allowed to be and the things that they're allowed to pursue. Obviously, this has not worked out as well as people had hoped, and so I think that there are some times where we see that that is actually not the truth. When you are in a situation where you are surrounded by other people who look like you, there can be power in that and there can be beauty in that, but there's also inherent messages being sent when in those sort of scenarios, you are not receiving nearly the quality education as some of our white counterparts, and that says a lot to how people can perceive themselves and their own value. So I hope that going forward, once we get to 100 years, that Brown can be a counter-narrative to this, that can be something that allows for people to see their own worth, something that encourages that and something that supports that. I hope that Brown is like a stepping stone for more anti-subordination jurisprudence in that sort of sense. I also hope that Brown at 100 years becomes more interdisciplinary, that it is something that is worked out in the courtroom, but it is also something that organizers engage in, that teachers are able to sort of co-opt in any sort of way. I don't know how they can do that, but I think that them taking on that sort of role as well and it just being something more holistic. But I also see that as a way that I hope that Brown's legacy expands to areas like housing, areas like I mentioned earlier, access to being free from pollution, access to quality health care, and all of these other really holistic pieces that make for just a sustainable and a quality state of life for people. And lastly, I think that I hope that Brown changes how we view what is meritorious out of a diverse education, that we can look at the historical narrative, the social narrative, the political narrative of what it really means to have a diverse education and the sort of values that that can bring. And so I hope that Brown at 100 is able to kind of fight against some of the things that the court may be understanding now and really see just the power and the amazing strength that diversity can create within our country.
Thank you.
I'm going to keep it short because I see the stop and that people need coffee. But the only thing I'd say, just a few quick things. One is I cannot wait 100 years. I mean, first of all, I'm not going to be here, but also it's already been too long. And so I agree, Brown, we have to reclaim equal citizenship, sharing of social goods, and this idea that the government has an affirmative duty to promote these things. I think that's at the core of Brown and the aftermath of Brown, and that we have to reclaim that, but it just has to be now. It's already overdue. And the other thing, I just would really attune us because we are so hopeful, and I want to end on a hopeful note, but I also want to say that the reason that we have a shift from the green world that Sam described to the Millikan sort of notion of remedy and the constraints on remedy is because of judicial appointments. And behind that is a political movement. And without a countervailing force to those things, there was the appointment of Nixon judges, some of whom didn't fulfill what he wanted, but eventually it led to the retrenchment, by the time you get to the Reagan Revolution. We have to keep our eyes on the right things. And then the last two quick things. One is that I have never understood why you have a world that you described after Reconstruction where Black students are trying to be educated and setting up an infrastructure, and why the whole country doesn't get behind that, right? Like, why do we see so the only answer for that is that there must be some other ideology that's a countervailing force, and it's either an ideology of white supremacy or an ideology against redistribution. When we see that, we have to show up with a different ideology. And where I get hope is where I see those moments of people organizing against that. And we see it all the time. In Brooklyn, they tried to dismantle their separate and unequal educational system that operates de facto through parent organizing. And you see pockets of that everywhere. And those are the kinds of movements that have to be sustained. They're saying we're not going to have a zero-sum ideology based on white supremacy. And we believe in a kind of non-zero-sum Heather McGhee culture and politics of abundance. And I think we need that in conjunction with the legal strategy.
Thank you. Mr. Pierce.
Yes, I also see the stop sign, so I'll be brief. Brown's, everything everyone said here, I totally agree with, but I just have to say this. I am so encouraged. Here in the last 2-3 months, I have met with so many young people who really have these, who coming together, working on some really serious issues to attack these problems, from higher education to K-12 to pre-K. And it is so encouraging to hear, these students, this student here and the young lawyers at LDF talk the way they do. I guess I've been away, maybe I'm getting old. But it's just great to hear all this because, sometimes you can get a little discouraged. Sometimes you look and you see the opposition in this sentiment that, some people should be kept down. That is a real sentiment. You look at it and sometimes it's just so overwhelming. You wonder, how can you ever defeat it? But Reverend Dr. King said, out of the struggle comes hope, right? Struggle breeds hope. And so I have a lot of hope. I'm really encouraged by this conversation. So thanks for inviting me. I'm glad to listen to this.
Please join me in thanking our panel.
Titled The New 14th Amendment. Before I introduce our panelists, who need no introduction, let me provide a roadmap for how this is all going to go down. Once I conclude my introduction, civil rights lawyer and scholar Sherrilyn Ifill will provide some opening remarks intended to frame this morning's discussion and ground us in the history and framers' intent behind the 14th Amendment. We'll then welcome Damon Hewitt and Jen Hee Lee to join the party and discuss the Equal Protection Clause in more depth while reacting to its most recent interpretations by the Supreme Court. Because there's so much to discuss and so little time, we will not be taking any questions from the audience, but I can assure you there is no shortage of books, lectures, and articles for those wanting to learn more about these civil rights icons. Okay, so without further ado, I'm going to bring up the panelists, starting with Jen Hee Lee. And I'm sure she's going to walk from behind that curtain any moment. But Jen Hee Lee is the Director of Strategic Initiatives at LDF. In this role, she leads the Department of Strategic Initiatives, which houses specific projects and campaigns that integrate litigation, policy, organizing, communications, research, and public education to provide impactful community-centered advocacy for Black communities. Jen also led LDF's representation of a multiracial coalition of 25 Harvard students and alumni organizers, which served as amici curiae in both the trial and appellate levels in the affirmative action cases, Students for Fair Admission v. Harvard. Welcome, Jen. See, I told you. Okay, next we have Damon Hewitt. Damon is the President and Executive Director of the Lawyers Committee for Civil Rights Under Law. Damon has more than 20 years of experience, civil rights litigation and policy experience, including prior leadership roles in the nonprofit, philanthropic, and public sectors. Prior to joining the National Lawyers Committee, Damon was the inaugural executive director of the Executives Alliance for Boys and Men of Color. He was also the chief liaison from the philanthropic community to the White House on policy issues impacting young men of color, a senior advisor at the Open Society Foundation, and an attorney at the NAACP Legal Defense Fund. Welcome, Damon. And finally, last but not least, Ms. Sherrilyn Ifill. Sherrilyn Ifill is a civil rights lawyer and scholar. From 2013 to 2022, she served as the president and director counsel of the LDF. Her tenure at the helm of LDF was widely praised for elevating the profile, voice, and influence of the organization, and for expanding and deepening its work across multiple areas of civil rights law. Sherilyn's voice and analysis played a prominent role in shaping our national conversation about race and civil rights during a tumultuous period of racial reckoning in our country. Sherilyn began her career as a fellow at the ACLU before joining the staff of LDF as an assistant counsel, where she litigated voting rights cases across the South. In 1993, Eiffel left LDF to join the faculty at the University of Maryland School of Law in Baltimore, where she taught for 20 years before rejoining LDF in 2013 as its president and director counsel. Sherilyn recently served as a Ford Foundation Fellow and as the Klinsky Visiting Professor for Leadership and Progress at Howard Law School. Sherilyn's currently the Vernon Jordan Distinguished Professor in Civil Rights at Howard Law School, where later this year, she will launch the 14th Amendment Center for Law and Democracy. Welcome, Sherilyn.
Stop it. Thank you so much. I am thrilled to be with all of you today, and I'm so excited to be part of this conversation, which we want to really have as a conversation. But let me acknowledge, first of all, Janae Nelson, our President Director Counsel, who's, there she is. Who is doing such a terrific job leading this organization, and in whom I just have so much pride and confidence. And so thank you for your sacrifice, because it is sacrifice to do this work. And to all of you, you know, the people who just won't give up, who keep trying to do this critical and important work for our people, for our communities, for the clients we represent, and for our country. This is the highest ideal of work, in my view, and it's part of what makes it so enriching and so important. No salary could ever achieve what the kind of bone-deep satisfaction that you get from knowing that you are doing critical work that is essential for the strengthening and the creating of a healthy democracy in this country. Not that a greater salary wouldn't be welcome, but so I asked, and I assume it's on the screen, for the full 14th Amendment to be put up on the screen, because I thought I would begin by trying to set the Equal Protection Clause in context, so that we understand the arc of the challenge that we're facing. Because what we have faced since 1868, when the 14th Amendment was ratified, is a sometimes slow, sometimes fast, sometimes aggressive, sometimes passive-aggressive hijacking of the promise and intent of the 14th Amendment, writ large. It started almost immediately after the amendment was ratified. And the reason I asked to put the 14th Amendment on the screen is because I do think we have to recognize that what we are working with, the 14th Amendment is largely the tool of our trade, is the most powerful and important provision of our Constitution. I know that it is not discussed or described that way, but I want you to think about the context in which it was drafted and then ratified. A country rent apart by a civil war, 600,000 lives claimed in that war. The project of putting together a country that is deeply divided, the project of trying to address the compromises that were made by the original framers, the compromise that led Black people to be counted in our democracy as 3/5 of a person, the compromise that conceded to the South power that its population should not have entitled it to, and the concession, the moral concession, on the values and principles first articulated in the Declaration of Independence, that we hold these truths, right? That all men are created equal. So these framers of the 14th Amendment are charged with addressing the compromises that the original framers were too cowardly to confront and deal with. And so it always amazes me that when we ask people about the founders of our country and the framers of our Constitution, they always talk about Hamilton and Madison and Jefferson. And, you know, if I did a straw poll even here, I wonder how many people would say John Bingham, the principal author of the 14th Amendment, or Thaddeus Stevens or Charles Sumner, or the many other people who are founders and framers who shaped the concepts that appear in the 14th Amendment in the decades before its ratification. Frederick Douglass, Sojourner Truth, the many free Black people who struggled to give meaning to the concept of equality and of citizenship. And their job then is to stitch together this country and to try to right these wrongs and figure out how to do it. And we get this document that is unbelievable in its scope. The very first line transforms this entire country. All citizens born in the United States are citizens of the United States and of the state in which they reside. Birthright citizenship. Created to ensure the citizenship of Black people, both free and formerly enslaved. That first line is the line that overturns Dred Scott. The first thing they have to do is deal with the Supreme Court's decision, which makes Black people stateless people in this country by saying that Black people cannot be citizens. That's just one line. The first line is that powerful. Not only is it powerful because it overturns Dred Scott, it's powerful because it reorders our sense of citizenship by putting our national citizenship first. Because prior to the Civil War, you were a Marylander or a Virginian. You weren't invested in your national citizenship. And this line now suggests a reordering of the priority of your citizenship and of the balance of power in this country. And this one line created for the 4 million or so Black people who have been formerly enslaved and for those who are free in the North transforms this country into the 20th century. To the extent there are people walking around calling this a nation of immigrants, it is only because by this line in the 20th century, waves and waves of European immigrants can come to this country and in one fell swoop, either by naturalization or by being born here, be American, fully American. There are many countries at that time in which that's not possible. You're German because your father is German. You're French because your grandmother is French. And so the very demography of the nation for the 20th and 21st century is shaped by that one line. Now, I only have a few minutes, so I can't go line by line with you, but I'm giving you a taste of the power of this document. And I had the incredible experience last week of being able to hold in my hands through glass, one of the original copies of the 14th Amendment. So that's just, first of all, just to get the sense of this document. Now, these folks are going about creating this thing, and they're going to bring Black people into the American citizenship. And as they're preparing to meet and do this, the leader of the country, the one person who everyone believes is the only person who can hold together the Union, is assassinated. And it's a real conspiracy, right? There's an attempt to assassinate his Secretary of State simultaneously. And I want you to imagine those conditions. The South is decimated. Everyone has lost someone in the war. And these are the conditions in which these people develop this vision. Their vision is so powerful that the first time the words equal in the context of kind of equal rights or justice appears in the Constitution is in the 14th Amendment. The first time the word male appears in the Constitution is in the 14th Amendment. This is a monumentally important and transformative provision of our Constitution. And the many people that you and I have fought against over the many, many decades, this is what they're fighting against. They are fighting against this transformation. Now, what's also really powerful about the 14th Amendment is that these framers, because of what they've been through, because they have been through this war, they are the only framers and founders of our Constitution who had to create something and fully recognize the truth about the spirit of white supremacy that exists in this country and the spirit of insurrection. They did a whole study in 1865 and went south to try to understand what were the sentiments, what is happening, what are the chances of us being able to pull this off. And they recognized that both white supremacist ideology and insurrectionist ideology was deeply baked into the South. And so this constitutional provision, unlike many others, provides tools that would equip us to fight back against the forces that would try to undermine the promise of Section 1 of the 14th Amendment. We don't learn about those tools in law school. We don't learn about Section 2, which has its own punishment regime for southern states that don't allow black men to vote. And we should talk about using that regime that's in the Constitution. We got a Voting Rights Act, maybe we should be using this one. That is reducing the representation of states that engage in voter suppression. And we got Section 3, which you now know about, but which I'm sure none of us ever read in law school, which was to ensure that insurrectionists could not serve in government and do with a gavel what they had been unable to do with a gun. So this is a very clear-eyed provision of our Constitution that has all the soaring language of promise, but that also understands you're going to need some tools to be able to fight for it. And of course, invest the power in Congress to pass legislation to fulfill that promise. But almost from the very minute it's ratified, the unraveling begins. The Slaughterhouse case, decided in 1872, but first, the litigation begins in 1869. The first case bringing a challenge under this new 14th Amendment. And who is this challenge brought on behalf of? White butchers in New Orleans, not black people. And you and I know that who the clients are is what shapes how we understand the rights and the narrative associated with those rights. Any of us who have spent time looking at affirmative action cases understand how they were shaped in the decades before black students and students of color were permitted to enter those cases. So we've got Slaughterhouse in 1872. We've got Cruikshank, the case that basically unravels the prosecution of the violent white insurrectionists involved in the Colfax massacre. That's 1875. The civil rights cases in 1883, which undermines the Civil Rights Act of 1875. Hall versus DeCour in 1877, which overturns the damage awards of a black woman who regards herself as Creole being removed from a steamboat ship. So it begins to happen almost immediately. And we, of course, know about Plessy versus Ferguson. We know about congressional inaction, the failure of Congress to pass any civil rights statutes in the 20th century, having been so slapped back by the Supreme Court in the 19th century, that in the 20th century, they just sit and watch through lynching and through Jim Crow. And they don't pass any civil rights statutes until the Civil Rights Act of 1957. Which basically creates the Civil Rights Division in the Justice Department. And we know about violence, which was the other way that the amendment was hijacked, by violence, insurrection, and so forth. I say all this to say that the project of understanding how we use the Equal Protection Clause has to be understood within the context of what our opponents are seeking to do. This may be a more passive-aggressive unraveling, but the goal remains the same. It may have been easier in 1872 to write a whole provision out of the 14th Amendment, privileges and immunities, in the Slaughterhouse case. A whole provision just unusable. And yes, they have to be more careful now, but they are doing it. And so because I think we tend to start the conversation as litigators from the place where the law has left us to try to imagine what we can do, I want to encourage us to think about reclamation. We cannot work with an equal protection clause this impoverished. We need a real one. And it's there on the paper. It's there on the paper. But we have to figure out how we're going to reclaim it. And I think there are a few ways to do that. Number one, I do think that we need to, since this court, not only because, but certainly since this court is so enamored of history, everyone needs to have a historian on staff. Because when you start digging into this history, as you saw with Section 3, you find so many important things that you need to be able to contextualize and to be able to challenge the kinds of interpretations that are being put forward. If we don't go back to that source, we are working with the interpretations that they have given. And so I want to encourage you to work with those original documents, to have historians on hand who are helping you regularly with the framing and the contextualization of this work. I think we have to think about, if we want to reclaim the Equal Protection Clause, developing a stomach for losing cases. Now, we all lose cases, so it's not as though that's so much of a problem. But I mean filing cases that you pretty much know you're going to lose. Because I do think, to go back to Alati's point in the last panel, there are multiple things happening at the same time. I want to applaud all of us who have worked incredibly hard to ensure the confirmation of judges in the district and courts of appeals who are waiting for new ways of thinking about this stuff. The question is, do you have something for them? Or are you just asking them to step out and work with the current interpretation and be overturned? That's part of why you have to delve into the history. They want the new information. They want that lost original provision of 42 U.S.C. Section 1983 that was recently discovered. They want that stuff. And so this is the time. You may lose some cases initially, but this is the time to begin to provide some meat to courts that are increasingly, because of the hard work of ensuring that we have judges on our courts who are open to these cases and who understand these issues and who have experience. We owe it to them to present them with something they can work with. And that means, again, going back to the beginning and giving them new data that they can use to challenge what have been the interpretations in the past. I also think we have to focus on the right narrative around these cases and understand how important it is to get in them. I'm thinking again about Bakke, for example, and the way in which we were left out of the affirmative action conversation that became a conversation about diversity and the rights of universities, and not about reparation and not about Black deprivation and the need for universities to address it. The consequences of that was that a whole discussion was hijacked. And we then started to fight within the context of that hijacking. I wonder sometimes, what if we had filed another case with an eye towards getting it consolidated with Bakke, once intervention was denied, because we did try to get into those cases. But I think we have to start thinking that way, of demanding to be in cases where we know the narrative is going to be shaped. What I'm suggesting by all of this is that this may be a time of building. I'm not trying to wait 100 years either. I have an 8-year-old grandson. I'm not trying to do it. But I do think that when things move, they move fast. They move fast. but it's not going to move if we are operating from this position of lack. This particular court is not one that can be convinced. And so we have to assume there's going to be a new court with some new justices on it. And I think we have to assume that it is our job to seed the lower courts with the data, the information, the theories that they need to be able to challenge the orthodoxy. We see it when we hear in oral argument Ketanji Brown Jackson working with those original materials, challenging the kind of interpretation that some of her colleagues are placing on these Reconstruction amendments. So we know it's possible. We know that they're ready to dig in and do the work. And I think that's what our job is in this moment. Thank you.
Well, wow. Thank you, Sherilyn. I think you've given us a great foundation for this conversation. Damon, Jen, I want to bring you in as well. Damon, I've heard you talk about the efforts to distort the meaning of the 14th Amendment as metastasizing right now. Wondering if you have more to say about that and any reactions to Sherilyn's comments.
Well, thank you, Andrew. First, thank you for having me, LDF. Thank you to Janae Nelson, amazing leader, for these times. Not to Dennis Parker, my first boss at LDF. So many great people. I'm not sure if I will really add to what Sherilyn said because she gave us a word. I was walking around Harlem this morning and somebody saw my collar and said, "Oh, you're a minister." I said, "Nah, not exactly, but Minister of Justice." Sherilyn gave us a word though from that pulpit. I guess the interpretations have metastasized, but not in an organic way, in a very orchestrated way, as Sherilyn mentioned. But there were a few things that Sherilyn's remarks made me think about. One is just the really important reminder that the 14th Amendment, the first sentence about citizenship, opened a door for formerly enslaved Africans born on this continent to be citizens, but also opened a door for waves and waves of European immigrants, right? And it reminds us that black folks have always been the canary in the coal mine, not just at the point of pain, but also at the point of possibility, right? And I think, what's good for black folks is often good for America. So if we can fix and address these wrongs, as she put it, then we can have a wider way of opportunity for all. That's a Lani Guinier type of worldview. Another piece that she made me think about is that context matters. Sherilyn essentially said that. Justice O'Connor wrote that, and the majority opinion in Grutter, and we'll probably come back to that later in this conversation. But I remember John Payton said at the Civil Rights Training Institute conference a number of years ago, before he was director counsel, he spoke about how Americans understand our reality in an ahistorical fashion, almost as if you start with the present and go backwards. And that is completely twisted. And so your call, Sherilyn, to wrestle with the material, the original material, is critical to doing what you always talk about, which is to change the material condition of today in a different sense. And then finally, racism metastasizes, and I think we have to really wrestle with what we do on our watch. It's not just win cases or try to win cases or fight a particular policy fight. We are part of a chain, a link that has to be unbroken. And in order for it to be unbroken, we can't be weak on the front end or on the back end. As Sherilyn said, operating from a position of lack. We've been talking at the Lawyers Committee about building what we call the future we deserve, because we know we can't just rest on defending what those who came before us developed, devised, defended. We have to build something new. So that's I'm looking myself in the mirror on that one as a challenge to my individual and our collective leadership about what are we going to do on our watch to have a future to defend at all. It certainly can't be the same thing that we've been litigating and advocating for decades.
Thank you very much, sir. And Jen, I know that you lead the Pro-Truth Initiative at LDF, and I'm sure history means a lot to you as well. I'm wondering if you have any additional reactions or comments in response to Sherilyn's.
So first, I just want to say that one of the great benefits of working at LDF is to work with civil rights champions like Sherilyn and Damon and many of the people out in the audience, and then now to be on stage and having this conversation. I think this is just, an example of how important that organization has been in the fight for civil rights, but also just, especially for the students out there, that, the history is being made, kind of contemporaneously, and it's being made by so many of the people in this room. And it's just really important. I'm glad that we're having this conversation about the 14th Amendment, because that it really is the heart of the civil rights and racial justice work that we all do. And there are two things that really stood out to me from what Sherilyn said. The first is the history, like that facts matter, and sometimes in this day and age of disinformation, it seems like facts can just be fabricated to be convenient for whatever argument you make, but we have to hold on to the truth that there is a truth. There are facts. There is a history. There is no kind of different versions of history. This history happened, and it's something that we should all remember and know about, and it's that history, I think, that really informs how we think about enforcing our rights under the 14th Amendment, because at its core, the 14th Amendment and the Brown decision, was a rejection of a racial caste system that we had in this country. I mean, there was a racial caste system imposed by governments that influenced and informed all aspects of everyday life for all Americans in this country. And that existed, as long as this country has been in existence, and it continues to exist. And when we talk about immigrants, in addition to European immigrants, Asian immigrants as well, I immigrated with my family in the mid-1970s. Every immigrant that came to this country entered into a racial hierarchy, whether you wanted to or not, because that is what existed in this country, and we are all part of that. And that is what gets lost when we talk about the conservative version of the Equal Protection Clause. This focus on individuals, as if discrimination only happens when one individual discriminates against another individual, as if slavery was just a product of individual, slaveholders, making these kinds of decisions about dehumanizing, Black people in this country, as opposed to it being a part of a racial caste system that was very much grounded in white supremacy. And that is what the Equal Protection Clause was meant to push back against. And that is what we need to do in terms of the work that we're doing, because we're not, we're not here to, kind of vindicate the rights of one individual. We are here to transform the racial hierarchy that continues to exist to one that is fully equal. The promise of the Equal Protection Clause, the promise of the Brown decision. So that history is so important, and it is absolutely being hijacked in this country right now. It's not a coincidence that a lot of these extremist legislations that we're seeing all across the country is targeting education. It's targeting how our children in this country learn about the United States, about its history, about our legacy with race, about what it means to be an American in a multiracial democracy, both at the K through 12 level and in higher education. That is not an accident. This is an intentional attempt to rewrite history for the purposes of maintaining the racial hierarchy that benefits a very select few that have always been in power. So that's the one thing that really stood out to me. The other is this idea of reclaiming the Equal Protection Clause. That, that for so long, we have been on the defensive, and I think the affirmative action litigation is a really good example, being kind of cabined in the diversity rationale, as opposed to really talking about the issues that matter, which is the continuing barriers to opportunity for Black students and other students of color, which, continues to get kind of minimized. And when you look at the other side, there is no limit to their ambition or their vision as to what they wanted to achieve, regardless of what the law was, right? And we've seen that happen just the past few years. Decades of precedent that we, had been stable, that had been the law for generations of people, has now completely been wiped away. And I think that it's our turn to take that, to have our own vision of what we think equal protection is in this country. And so, it's because of those two things that, that we have two initiatives at LDF. One is our Pro-Truth initiative, which is very much focused on making sure that the curriculum that's being taught to all children in this country is accurate, factually accurate, inclusive of all people's history and experiences, and very much is unapologetic about the need for students to know about our legacy of racism and the obligation of every citizen in this country to actualize the promise of the Equal Protection Clause, as well as the Equal Protection Initiative, again, which is another initiative we have to really kind of reclaim the Equal Protection Clause and really think boldly and broadly about how we can advance the law in that area.
Thanks, Jen, and I really appreciate you mentioning student organizers as well at the beginning of your remarks. We know that student organizers have, throughout this country, throughout our history, been on the forefront of many of these movements. Sherilyn, I want to bring you back in. We're here for a conference about Brown. Another quote from Brown, other than all deliberate speed, is that education is perhaps the most important function of state and local governments. What is it going to take for us to reclaim the promise of Brown?
Well, I think that we have to ourselves define what these cases actually mean and say. The language that you just read is not the language that people associate with Brown. That education, said the court, is the very foundation of citizenship. If we're fighting on this education front now, if we're fighting on this pro-truth front, we should be saying that every day. We didn't say it, the Supreme Court said it. Education is the very foundation of citizenship. The Supreme Court said in Brown that education is the most important function of state and local government. So when you get your city budget and you look at what is allocated for education, are you challenging whether or not that budget reflects the Supreme Court's command that it is the most important function of state and local government? I think we allow the impoverishment of even our wins by not boldly stepping into the full language. And I see this in any number of cases where we allow it to be shrunk to a soundbite instead of dealing with the richness that is available even in Brown. The flip side is true also. We allow the cherry picking by our opponents of language without calling them out on the internal contradictions of the language they pick. When the Chief Justice of the United States says in SSFA, our Constitution is colorblind and there is no case here, and it's a beautiful paragraph in the dissent in Plessy. But a paragraph later, Justice Harlan says, there is, however, a race that is so different from us, right, that we do not even allow them to be citizens. And what he says is so outrageous is that we would allow them to sit on rail cars with white people, and we don't allow black people to sit on rail cars with white people. So he's championing integration for black people, but says there is a race of people so different from us. I mean, of course, the Chinese. So when we allow statements to be made like our Constitution is colorblind, which we don't believe anyway, but we don't actually challenge the distasteful willingness of the Chief Justice of the United States to pull and stand behind a quote in a dissent that he would probably never agree to today as a majority opinion, without acknowledgement that that same justice just a paragraph later presents the most odious caste and discrimination that you can imagine. So there's a way in which, again, we're jumping from lily pad to lily pad as well. Sometimes with the decisions that are favorable to us, sometimes with the decisions that are not favorable to us. I think we have to deepen the scholarship of this if we want to have judicial decision making that has integrity. Right now, the equal protection jurisprudence of the Supreme Court lacks integrity. And I think we have to call it out. The other piece I think is, Jen said facts matter. That is part of the project too. That's why they don't want litigation to happen, because litigation is the making of facts, right? It's what I love about litigation. You know, we all allege some things and then they answer and they're all just allegations and they go through this whole process and there's discovery and depositions and all kinds of stuff. And then we do a trial and we come out the other end and the judge makes findings of fact and conclusions of law. And those findings of fact are very hard to overcome. They're entitled to deference. Now, the thing that your clients told you in the meeting has been made real and factual. And that's the power of civil rights litigation. That's why they don't like trials. But when we do it, as in SSFA, which Jen and many others did such a masterful job in, the Lawyers Committee as well, and the allegation that race-conscious admissions harms Asian American students is actually disproven. And that disproof is upheld on appeal. And it gets to the Supreme Court. The Supreme Court's like, well, yeah, well, but anyway, our Constitution is colorblind, right? So they're not even gonna deal with, that's a pretty serious, a damn serious allegation to say that race-conscious admissions that aids Black and Latino students harms Asian American students. That is very toxic. But we met it. We met the challenge and we proved it did not. So you know what we should be talking about with SSFA? That's what we should be talking about. Because they can't take that away. All they can do is change the goalposts and change the rules of the game, which is a pretty big deal. But we should not give away the facts that were proven that are significant and important. They matter. That was what the whole darn claim was supposed to be about. And they did not prove it. And so let's make sure we continue to underscore that reality.
And you know, those comments from Justice Thomas are especially ironic in the context of how the SFFA versus Harvard case came to the court on behalf of Asian Americans. Sticking with SFFA for another moment, Damon, you know, as you know, I'm actually a UNC Chapel Hill graduate. When I started at UNC in 2014, the school was 11% Black in a state that was 22% Black. I had grown up in the South my entire life, but it wasn't until I was a student at UNC that I witnessed my first and my second white supremacist rallies on campus on my way home from class. And so when I heard my sophomore year that a group called Students for Fair Admission were suing the university, let me tell you, I assumed that they were trying to address those disparities. Boy, was I wrong. And so my question for you, Damon, is considering the Students for Fair Admission cases and other recent legal battles, what are the key arguments and counter-arguments surrounding the Equal Protection Clause's role in addressing affirmative action policies?
Well, Andrew, you were more than a student. You were a client, you were a leader, and you continue to be. And now as a Marshall Motley Fellow at LDF. So, without rehashing what the battle was, to look at where we are today and going forward, the battle is really one about whether the 14th Amendment is a project about formalistic legal equality or whether it's about something different. In the piece that Nicole Hannah-Jones wrote recently in the New York Times Magazine, she quoted LBJ, who had his own issues, but also was very important for so many reasons, from a commencement address he gave at Howard University in the mid-1960s. He said, "We seek not just legal equality, but human ability. Not just equality as a right and a theory, but equality as a fact and equality as a result." So when I think about meta-narratives that we subscribe to about opportunity and level playing field and what have you, those are important, but damn it, what I'm after is a result. I'm after just outcomes, not just opportunity in the abstract. And so when I think about the fight about SFSA, when you look at the context about why the university was created, to educate the children of slaveholders, the white children of slaveholders, not the black children they did not cognize and respect. And Justice Ketanji Brown Jackson said it best in her oral argument, that if you are a white student who's a legacy for 5 generations, you can talk about it all day long, but if you're a black student, you're being told somehow that not only can you not talk about it, but it doesn't matter. Now, the Supreme Court decision did carve out a space, that line that says that nothing in this opinion prohibits universities from asking students about their experiences with race, whether it be discrimination, inspiration, or otherwise. So we don't have time to go fully into that, but I hope that comes up later in today's conversation, because it's important, certainly from a First Amendment context. But I think the point is that we have to wrestle with, are we after just equality as an abstract or equality as a result? What does justice really look like for us? I think that's what the continuing fight is about. I also think that, I'm going to answer a question you didn't ask a little bit, Andrew, but we talked in the prep about how equal protection jurisprudence has evolved over the years. I want to call out Washington v. Davis in the intent requirement. And I'm actually going to bring it back to something that Brother Malik said on the panel earlier. He talked about more anti-subordination litigation and jurisprudence. The way that the 14th Amendment has been hijacked is in a way where it's not really about anti-subordination. It's really more about that formalistic legal equality, certainly not equality of result. And so when you think about subordination, what's more subordination than telling a university and telling black and brown applicants to university that your experiences, your lived experience, is something that should not factor in the admissions decision, regardless of the history of this nation, the history of the state, the history of that particular institution. And I'm sticking with UNC, not Harvard, because state flagship institutions in particular owe something to their own people, especially institutions that have enslaved people, or states that have enslaved people in the past, right? So I think that we have to redefine what the fights are about, and it cannot be just a simple pursuit of formalistic legal equality. It has to be something more. I think formalistic legal equality is the narrative that Chief Justice Roberts has been using in so many cases. One thing I'll say in closing on this is, when I think about a path forward, I think about what some call the Pollyannish view. When LDF won the Milligan case in the Supreme Court, the Alabama redistricting case, there was a narrative I developed in my own mind about what was at play. So the Solicitor General had this cockamamie argument that, well, we can't create a second majority black district because doing so means race predominates in the consideration. And you've told us, court, that that is unconstitutional. Therefore, we cannot enforce Section 2 of the Voting Rights Act to create that second majority black district. Of course, the court rejected that cockamamie argument. And so my thought was, well, maybe this court or someone could recognize that not only are race-conscious remedies and interventions designed to address wrongs permissible under law, maybe sometimes they're actually required to achieve the just result. So I think that's the kind of thing that I'm playing with, and I encourage us all to really wrestle with about how we can focus on a more results-oriented piece that's either within the bounds of existing law or maybe outside of the box.
Yeah, one of the many fallacies of that decision is this idea that you can create a race-blind admissions process when our country itself simply isn't race-blind. But sticking with you just for another second, Damon, I've heard you describe something called the third Reconstruction. Sounds great. What do you mean by that?
Well, it's not my original and singular idea, obviously. Others have written about it. But if you think about the first Reconstruction, the second founding, as a fundamental reordering and restructuring of the relationship between and among America's citizens and residents, and the relationship between the people and the state. If that's what the Reconstruction era was, at least for a dozen years of active Reconstruction, and of course with the 13th, 14th, and 15th Amendments. The second Reconstruction, during the Civil Rights era, the Civil Rights Act of 64, Voting Rights Act of 65, Fair Housing Act, what have you, did much the same, perhaps on a different scale or plane, but much the same. So if we're building a future we deserve, maybe we need a third Reconstruction that once again fundamentally restructures the legal and political and social relationships between and among us and the multiracial democracy, but also redefines and restructures the relationships between us and the state. And so that means, in my view, positive rights, not just the right to be not discriminated against, that can be hijacked and bastardized. I think that also means pushing towards equality of result.
Absolutely. And speaking of our multiracial democracy, Jen, just to you for a moment, increasingly this country is getting close to being a majority-minority country. Folks have increasingly intersectional identities. What is that going to mean for the 14th Amendment, the Equal Protection Clause, and where we can go from here?
Well, I think that, and as Sherilyn pointed out, such a key and central focus of the 14th Amendment is citizenship and full citizenship. And when we talk about exercising the rights or having the privileges of full citizenship, which has been denied to Black people, other people of color, but it's also being denied based on sex, gender, LGBTQ plus people. The legislations that we're seeing right now is simply horrific. And I think that the idea that, and it's a beautiful idea, that America is a multiracial democracy. Because that in itself, to say that it's a multiracial democracy, it says so much about the potential and the resources and the joy of all of these different people coming together to build, the best country that we can. And again, I think oftentimes when we talk about the affirmative action cases, a lot of people think that it's just a case about people trying to get into these selective universities, and who cares about that, right? This is not a matter that affects me, but I just think it's just so essential to understand that at the core of the affirmative action cases is this notion of this idea that it is perfectly natural. It's a natural course of events for this country to be racially segregated in our most selective institutions. That's essentially what the opponents to affirmative action are saying, and people who are proponents of race blindness. That we live in an equal world, and that if some people can't get into schools because they don't have the qualifications or merits, and that's perfectly natural. And if you think about that, and if you read the cases like Plessy, and talking these odious statements about the natural inferiority of some people because of their race, like how similar that is, as opposed to just the simple logic that the people who are being excluded from these institutions happen to be the same people who have suffered the most when it comes to racial discrimination in this country. And I'm really glad that you mentioned the kind of the tactic of using Asian Americans as a wedge, because that too, there is an odious racial stereotype associated with that, because people have jumped on the bandwagon that Asian Americans are just naturally smarter and naturally able to kind of excel in these standardized tests, when in fact you take a step back. I mean, first of all, I did not do well on standardized tests, and I'm Asian, so it's not, the logic doesn't make sense for a lot of Asian Americans, but you know, as opposed to what are the resources, what are the reasons why this particular group of people may, you know, statistically do better? Like, there's reasons behind it that is not connected to racial inferiority or racial superiority. And that is so important if we truly believe in having a multiracial democracy, because that means that everyone, regardless of their race, is a citizen, and that we as a country need to benefit from the resources and the talent of every single citizen in this country, regardless of their race. And as you said, the different intersectionalities as well, and that's what would really make our country thrive and be productive and all of that. And that's what's at risk with this kind of movement to attack the Equal Protection Clause and the interpretation of Brown.
It's such an important point to make, and you know, this meritocracy myth really clouds a lot of the conversation around affirmative action. You know, we know that Harvard could admit an entire class full of people with perfect ACT scores if it was really just about ACT scores. Okay, our time is up. I'm gonna let each of you have a final word. The question I have for you is, how can advocates leverage the Equal Protection Clause to address contemporary civil rights challenges such as racial profiling, voter suppression, and disparities in criminal justice? And Sherilyn, I don't know if you want to hop in there first.
Well, so first of all, I think we are doing that. You know, I think the Equal Protection Clause is central to all of that work. But I think what's missing is, if you just go out, let's go off this campus onto any street and ask people what the Equal Protection Clause is, they have no idea what you're talking about. Ask them what the 14th Amendment is, and they have no idea what you're talking about. And we're talking about the constitutional provisions that give most of us the sense of what we're entitled to in this country and what cannot happen to us and what we deserve. So the first thing is that, but if you go out and ask people what the Second Amendment is, they're going to know what that is. If you ask them what the First Amendment is, it's not going to be perfect, their description of it, but they're going to kind of know what it is. So one of the reasons I started this 14th Amendment project in this center that we'll launch in the fall is to try to inculcate a narrative that gives people facility and familiarity with this important provision, so that when in litigation you're raising it, and you're raising it as a provision that you're using, people understand what it means and have expectations of what it is supposed to produce. So I think that first and foremost is really important. I also think that writ large, we all have to become much more militant about protecting the provisions of the 14th Amendment that stand around equal protection. As Jen has been saying, I mean, to my mind, citizenship is the most important piece, because that was the point, was to ensure that Black people were citizens and that there was no caste system. And the reason why the 14th Amendment is so long, even though you only learn the short version in law school, is all that stuff is in there so that you can protect that. Because they knew that it would be challenged. They knew it would not be accepted. They knew it would be resisted. And they tried to give us the tools to challenge it. So I think understanding the citizenship elements, when politicians say we're going to end birthright citizenship, you need to be speaking as civil rights lawyers. You need to be saying that is a provision of our Constitution, and you can no sooner, as a policy matter, rid this country of it than you can of the right to bear arms. Why do we let them talk about our amendment that way? Why do we let them talk about citizenship that way when that citizenship was created for us? And now Lindsey Graham is going to say we're going to end birthright citizenship? We put that somewhere in the immigration category, and I don't hear civil rights voices when they say that. So I think we have to become much more protective about the infrastructure that surrounds it. I think you need a plan to overturn Slaughterhouse. I think we need the Privileges and Immunities Clause, not for the reasons that Clarence Thomas thinks we need it perhaps, but it was read out of the Constitution in 1872. And if you read Slaughterhouse today, all the other parts of Slaughterhouse have already been discredited, right? The court in Slaughterhouse also says, we can't imagine a circumstance in which the Equal Protection Clause would be used for any other group besides formerly enslaved people, besides black people. That's what they say in Slaughterhouse. Meanwhile, right, the Equal Protection Clause is obviously used for women, it's used for the members of the LGBTQ community, it's used like hell by corporations, right? So all that's been discredited. Everything around the Privileges and Immunities part of Slaughterhouse has been discredited, but we're supposed to continue to believe that that decision in that court was equipped to read out of the Constitution the Privileges and Immunities Clause. So I'd like to see us, Tom Syens is fond of saying we should use the whole Constitution. I think we need to be using the whole 14th Amendment.
Damon?
Well said. So, love that. In that spirit, we have to use the 14th Amendment in addition to learning about it and socializing it. And so some of the cases, like the project that Jen is leading and the litigation that I know LDF is in Florida against the Stop Woke Act, and that we're in Oklahoma, where teachers are afraid that they can't teach about the Tulsa Race Massacre or the Trail of Tears, facts of things that happen to people on Oklahoma soil. We're all using both First and 14th Amendments. And I think it's important to use them, but use them in parallel. To channel Pam Carlin, the former LDF attorney and Stanford Law professor, she talks about the 11th Amendment, that people think it somehow trumps the 14th. Well, Sherilyn's remarks point out people think there's a 2nd Amendment. And so we have to bring the 14th to a relevance in discourse in terms of what we accept and what we expect, and also in terms of rights and jurisprudence. We have to bring it to relevance and prominence once again, and that means leveraging it. We also need new paradigms for pretty much every institution. The former dean of my law school wrote a letter to alumni about 15 years ago, and he wrote about how the median LSAT score is so high, he said, I don't think even I would have been admitted. And it struck me that he was equating success with exclusion. About how many people can we exclude? How selective can we be? And so if we demand that our institutions be mission-driven toward multiracial democracy, maybe you start to see things a different way. So I think we need a press from the courts and also a press from within institutions to change how they do business. So we do not accept the bad results of who gets admitted to these schools. We don't accept the specialized high schools scam in New York City, which still burns my blood to this day. Where so few black students out of hundreds and thousands are admitted to the city's most selective schools, all based upon normative criteria and an issue of eliteness that we know produce inequitable results. That, as Justice Ketanji Brown Jackson said during an oral argument, that kind of colorblindness actually presents more of an equal protection challenge than it solves.
Jen?
So I'm going to build upon what the really important things that Damon and Sherilyn said, and then and kind of, harken back to the first panel and bring up remedies, because you can go to court, you can win in court, but what really matters is the remedy that's imposed, because that's what's going to affect, the day-to-day lives of everyone, and that's not an easy thing. I've been a part of this litigation. We talked about the criminal justice system, the criminal legal system. I've been a part of this litigation against the NYPD for over a decade. It is not easy. It is not easy. And what I've realized is that what's not easy is something that we don't often do, which is envision what is it that we want? Like in kind of the nuts and bolts, everyday thing. What is it that we want, that we think would create equality in the criminal legal system, in the educational system, and so forth? And I think that's a question that doesn't involve just lawyers. Like, that involves everyone. That involves educators and academics and young people and people who are experiencing the discrimination on the ground on a day-to-day basis. But that is so important, because we can say that, and as Damon pointed out, we can formally say that we have rights, but unless we actually experience them and see them come into fruition, then it's kind of just words only. And I think connecting the remedies and what the results of civil rights litigation or policy making, organizing is to the vision that we have when it comes to the Equal Protection Clause is so essential and something that we should all be a part of.
Well, Damon, Sherilyn, Jen, thank you very much for being here with us today and for your dedication to the movement for racial justice. Join me in thanking them.
Thank you.
Thank you all.
This event, I think, shows you the intention with which we plan to continue to enliven the conversation around Brown for the next year and years beyond. So I want to thank her for her leadership, along with Sarah Saw, who is a policy counsel who also has played an integral role in organizing this event. There are many more staff members that I will acknowledge, but I had to at least say that to start. So, as you've already heard, 70 years ago, LDF's founder, Thurgood Marshall, along with a mighty group of lawyers that included our second President and Director Counsel, Jack Greenberg, and James Nabritt, and George Hayes, and Robert Carter, and of course, the inimitable Constance Baker Motley. They and their intrepid clients dared to challenge legal doctrines, racist doctrines that codified Black people as second-class citizens, that denied us equal access to education, and by extension, access to opportunities to improve our human condition. Brown versus Board of Education of Topeka, Kansas, and the 5 consolidated cases of which it is a part, did not endeavor, as you've heard in the panels today, to simply put Black and white students in the same classroom, even though that in and of itself would have been and has been an act of epic social defiance. That was not the end goal of Brown. Rather, Brown's architects sought to debunk the premise that separate but equal could ever be consonant with the 14th Amendment. It could not be consonant with the mandate of equal protection under the law. So Brown sought to establish that forcible separation of the races by law was indeed a badge of inferiority, as the court in Plessy versus Ferguson suggested, but did not hold. While Brown and its necessary follow-on, Brown 2, finally ended state-sponsored de jure segregation in public schools and opened pathways to educational opportunity that frankly was unimaginable at the time of emancipation a mere 9 decades earlier. The ultimate goal to guarantee equal access to quality educational experiences that respects the intelligence, the dignity, the humanity of Black students and Black people more generally is one that we are still fighting to realize 70 years later. So as I reflect on where we are today, I hear an echo that goes back to Brown 2 in 1955, when Chief Justice Earl Warren wrote for a unanimous Supreme Court nearly a year to the date of the Brown decision and mandated that recalcitrant school districts act with all deliberate speed. The title of this opening convening, all deliberate speed. What does that mean? The panel explored that a little bit earlier. And I would say that that very hollow and lymphatic instruction to carry out the rule of law and desegregate schools across the nation at an undefined pace empowered massive resistance, and it shaped the future that we now face, where we are looking to advance the promise of Brown without the power of that full decision. Brown has helped to shape the identity of nearly 3 generations of residents in this country by defining what it means to live in a multiracial democracy. Brown made clear that equality is interdependent and involuntary separation by race dehumanizes us all. The dynamic culture that is America's brand is a reflection of the integrated society that Brown set in motion. We are all beneficiaries of Brown. We are beneficiaries of the free and open society that Brown created. We are heirs to the still nascent democracy that could never have flourished under segregation. We are all legatees of the clarity brought by exposing the myth of white superiority. We are all the products of cross-pollination of ideas set in diverse educational environments. We are all Brown. We all therefore have an obligation to disrupt those who are actively working to undo the progress of the last 70 years. And I submit that one of the ways to do that is to counter the massive resistance that followed Brown and that continues now with massive engagement. It is a tool that we did not have at our disposal at the time of Brown's decision because we did not have the same investment in this integrated society that we have now. So it is not just those of us who care most deeply about Brown, who see ourselves as the direct beneficiaries of Brown, who should be doing the work. It is all of us, because Brown undergirds the very society that we enjoy. And so I appreciate milestones like this one and events to commemorate Brown because they offer an opportunity for robust discourse and ideation that can spark the creative strategies that will re-energize those of us in this movement, hopefully recruit others to it, and inspire all of us to rededicate ourselves to the project of refounding this multiracial democracy. I think we've seen that reconstructing an edifice that was never meant to deliver justice to us may be a fool's errand. So I am advocating for a refounding of this democracy, that we look at the foundations and the underpinnings of what makes us a multiracial, multicultural, multi-ethnic society, and we think about what is missing. It doesn't mean that we jettison any of the commitments that have gotten us this far, but we think about what's missing and we fill the vacuum and fill the void so that future generations do not have to relitigate the same struggles. And we're eager to engage law students in this conversation, and I want to thank Columbia Law School for hosting us. I want to make sure that we shout out the law students because they will ultimately be responsible, along with their peers, in carrying this charge forward. Andrew Brennan said that the most important piece of knowledge we needed about him was that he was from Kentucky. I will contest that and say that one of the most important facts about Andrew is that he is a Marshall Motley Scholar, named after Thurgood Marshall and Constance Baker Motley. The Legal Defense Fund is building the next generation of freedom fighters, of strategists, of change makers, of visionaries through this program that is seeding the South with people who are committed and trained to advance racial justice. And Andrew Brennan is just one of 30 students that we currently have in law school advancing that charge. So I'm delighted to be here in conversation at Columbia Law School, and LDF and our many partners continue to work as defenders of equal opportunity and educational equity, and as fierce protectors of Brown's true legacy and intent. I invite you all to join us. I look forward to being in conversation with you, and I hope that you will also be a steward
of this sacred trust that is Brown's legacy. It is one of immense reward and responsibility. Thank you.
Janae, thank you so much for those remarks. After 70 years, I think we're all ready for a refounding. As the leader of the NAACP Legal Defense Fund, an organization with obviously deep ties to the legacy of Brown, how do you personally understand the lasting impact this landmark case had on the pursuit of racial justice in America?
Well, as I mentioned, I think that Brown permeates nearly every aspect of our current modern society. We often say it is like the air we breathe. It is something that is almost invisible to us because so many of us grew up and were born into this post-Brown society. And we have certain expectations of what it means to be in America where we can take advantage of the diversity that it has produced, where we can take advantage of the freedoms that Brown has helped to instigate. And Brown, while it deserves a tremendous amount of credit, and the 4 of the cases that are consolidated with it, builds on a strategy that began well before it. And it is the culmination of that work like the challenge in Sweat versus Painter, even the Mendez case, a case that was in the late 1940s that held that the segregation of Mexican American students from other students was unlawful. So Brown really set in motion a whole new vision of American democracy that was then solidified by the Voting Rights Act that really brought true representation into the corridors of power. But what I think we are missing in some ways is that Brown is almost a victim of its own success because we have begun to take for granted this society that we have inherited. But I hope that we see clearly now that there is an effort to roll back those gains and that there is an effort to recast Brown from what it was originally intended to produce. And if we want to keep this multiracial democracy and actually have it fulfill its promise, because the status quo is still not satisfactory, we must look at the original intent of this all-important case and make sure that we ultimately fulfill its promise.
You know, on that point about how sort of the landscape has changed today, I'm wondering sort of how LDF has translated the legacy of Brown into practice today. How the organization continues to draw inspiration from the principles upheld in that case in its advocacy?
Well, our director of litigation said earlier today, we actually have lawyers in Louisiana as we speak in an evidentiary hearing pushing back against discrimination within public schools there and proving through the testimony of experts and clients and parents how our schools have resegregated themselves or in many ways never fully desegregated. And we try to make sure that with the vast docket of segregation cases we have, that we have not lost sight of what Brown's ultimate intent was. And it wasn't simply to make sure that Black and white children learn together. That's a lovely ideal, but it's by far not what the ultimate goal of this work is. And so we bring the principles of equity and citizenship and democracy into the way we envision what a public school system that will produce the next generation of citizens should look like. And that's the sensibility that we bring to the work in all of the education work that we do, and frankly, even beyond.
Now, Saba, I want to bring you into the conversation. You are one of 2 co-founders of Brown's Promise, a new organization focused on the intersection between school integration and school funding. And it really is new, right? You launched less than 1 year ago. Can you tell us a bit about it? Why this work? Why now? And how does the legacy of Brown shape what you're doing?
Sure. So we did launch last summer, so we're very, very new. My co-founder, Ari Americano, and I launched Brown's Promise because we see school diversity and resource equity as inextricably linked, yet we have two very distinct conversations in this country about those two issues. And you can see that in our professional backgrounds. We were both at the Department of Education. I was in the Office for Civil Rights, where my portfolio included diversity, civil rights, obviously, and Ari was working on funding equity, and those conversations did not happen in the same room. And so when we got out of the administration, we thought a lot about, like, why is that, and how can we actually bring those two ideals really together? Because we really can't see an end to educational inequity without ending school segregation. We just know the pattern in this country is that, as Ari often says, green follows white, and we have created a system in which predominantly white schools, predominantly wealthy schools, have more money and more resources than schools serving students of color. So that's really our goal, is to bring those two together in a pursuit of well-resourced, integrated schools. And we're doing that through research. We think there is important research questions that need to be answered if we're going to do this work in the courts, and through advocacy. We're actually bringing advocates together who work on these two kind of distinct issues of school finance and school diversity. And then we're also trying to reinvigorate the national conversation around integration. You rarely hear politicians even utter the words. It's like they're like afraid to talk about children learning together from the bully pulpit. And so we are, like, conversations like this, reinvigorating the national conversation and bringing school integration back in as a strategy and a solution for ending educational inequity. And one last thing I'll say that really excites me about our work, I am a beneficiary of LDF's work, specifically LDF's work in Hillsborough County, Florida, where I got to go to well-resourced, predominantly white schools as a result of a desegregation plan that was negotiated with the district, changed the trajectory of my life. It was also a very difficult experience, and we know across the country that many black students, many students of color, had difficult experiences as a part of integration. So it excites me to learn from both my experience and our experiment with Integration 1.0 writ large, to learn from that and build a multiracial democracy that really creates integrated schools that don't put the burden squarely on communities of color, and allows us to think about what does this new public education look like, where students are taught culturally sensitive pedagogy, where we have multiracial teaching staff, that we really are working together with organizations like LDF to really envision what public education can be.
Now, I've actually had the privilege of working with Brown's Promise a bit over the past year. And in that process, I've learned that you're really focused on district lines specifically. Why that focus, and how exactly does that relate to Brown's legacy?
Sure. So as we started getting into launching Brown's Promise, we read a great article by a law professor you all probably know, Derek Black, which really gave the history of kind of school district lines. We talked a lot about Milliken today. It has a great passage where he suggests that the Supreme Court really historically read in the importance of school district lines into Milliken that really wasn't historically correct. So district lines, we have seen, cause 2/3 of the segregation in public schools in America. And of course, we know district lines drive inequities in school funding and school resources. Yet we never talk about them. We don't talk about changing them. We don't talk about how they came into existence. And that's a choice that policymakers, that all of us make every day, not to challenge a system of school district lines that segregate students and keep students from resources. And so we think it's really important to start really focusing on that and what can be done about school district lines. Again, referring back to Milliken, 50th anniversary this year, an incredibly important case that really did end the ability for us to change, have multi-regional district integration plans. But at the state court level, we still think that there's progress that can be made on this issue. There's 2 cases right now being litigated in Minnesota and in New Jersey that are challenging state practices that have facilitated school segregation using state constitutional law. And so we see a path forward through state courts with the very specific goal of trying to challenge the state practices, which really boil down to maintaining segregated school district lines. We really think there's a future there in advocacy.
Well, we're really excited to see the work play out. Janae, I think I heard backstage that Saba was actually your paralegal back in the day. Is that correct?
That is true.
Well, we're excited, very excited to have you both on stage with us. It really is sort of a full circle moment. In addition to being what I'm sure is the best paralegal you've ever had.
Ever.
What's exciting about the work and vision that Saba is describing? How do you see sort of LDF fitting into that work? How do these two organizations collaborate? Sort of what does the next 70 years look like?
Yeah, that's a really great question. So, Saba really represents so much of what we try to cultivate at LDF, and that's, a new generation of leaders that goes on to iterate some of the work that we do and complement the work that we do, and that's exactly what Brown's Promise is doing. The fight for equitable funding in schools has been a long and tortured one. We know that there are formidable barriers, but there is some possibility at the state level, and it's something that we have considered and welcomed so many other players in the field, given the vastness of this problem, and the fact that LDF maintains a docket of roughly 100 desegregation cases. So we have our hands full. In addition to the work that we're doing in higher education, in addition to the pro-truth work that you've heard about earlier, and then other visions that we have for producing education equity. So we welcome the partnership of other organizations like Brown's Promise that can, help complement all of these strategies. And the work that Saba described about district lines is particularly important when we think about the takeover of school boards across the country that is also connected to how district lines are drawn. It's not only about what students are included in those parameters of the districts, but also, who gets to run those school boards, who gets elected to those school boards. And that's part of the non-litigation strategy that I think is critical to making sure that we do not cede the public education space to actors who have nefarious intentions by not recognizing the power in school boards. And we have an entire report that the Thurgood Marshall Institute produced that describes why school boards are important, and an entire podcast about it that I commend to everyone. But that's the type of work that Saba's organization can help lift up, and that LDF, and given our experience, can amplify even more. So we've been talking, I think your ultimate question was, what do the next 70 years look like? I have said many times that I think in these moments where there are these tectonic shifts, where there is a pitched cry for change, and there is a sort of earthquake that is shifting the potential direction of this country, that there is an opportunity in these moments of tumult and turmoil, and that it is up to us who have committed ourselves to this work to really seize that opportunity and see the through line from the work of Brown to advance opportunities for the next generation. So I envision the next 70 years being ones that look like the rapid progress that we have seen for the past 70 years. I think we underestimate how much has changed in the relatively short time since emancipation. And my hope is that we will see a more turbocharged transformation of this country, where we've learned from the mistakes and the missteps of the past, and we have even more people galvanized to preserve and advance our democracy and its ideals.
To your point about plenty of work to go around, for the students in the audience, you will never run out of a job if you choose to go into educational equity work.
Amen.
I think I have another question for both of you, and then I think I understand you may have some questions for me. Before we open up to the audience after that, we've been talking a lot about legal strategies and legal theories, and obviously for good reason, a lot of this work has been legal. But when you look to the next 70 years, what role do you see for other components of this work to fulfill Brown's Promise and advance this legacy, whether that's policy advocacy, grassroots organizing, applied research, public awareness raising, something else altogether?
Sure, I'll take one piece of that. obviously at Brown's Promise, we think that there has to be a multi-pronged strategy. We are working with local advocates to launch a state court litigation strategy, but we know that won't be successful unless we've built an infrastructure on the ground of grassroots advocates who are agitating for well-resourced integrated schools, who see the connection between school funding and segregation. So the grassroots organizing work of this is so important. But I do truly believe we need a robust field of leaders talking about this, talking about Brown at 70, talking about the resegregation of our schools. Nicole Hannah-Jones has a great quote, I'm going to paraphrase, where she says that the fact that Americans believe that the brief period that we tried desegregation was a failure speaks to the most successful propaganda campaign of the last half century. Integration was not perfect, but it was transformative for many students. It was a brilliant legal strategy that, as you said, was not aimed at just having black and white children sit together, but radically changing the face of public education. And part of that was making sure that black students had access to the resources that have been denied to them. Why we would ever walk away from a success like that and advocating for a success like that is beyond me. So, making sure that we acknowledge ways that integration could be improved upon, making sure we acknowledge what we understand about what students need in the classroom today, but we need leaders out there actually talking about this work and agitating for it.
Yeah, I agree with everything Saba said. We try to bring a multiplicity of tools to the fight for education equity. I talked about the conversations that we've had about school boards, but the undergirding research is so important to help shift the narrative, to inform the conversation and the policies. So I will shout out again our Thurgood Marshall Institute that has done exceptional work. I'm looking at Keisha Moore here in the audience, who has helped to author a report about black educators and taking insights from a field study that we've done about what helps black students learn. And it's very clear that having black educators in their environment is transformative in terms of their success and realizing their full potential. If we look at our public school system, we have a system where 79% of the school teachers are white and over 50% of the students are black and Latino. And it is a skew that has unfortunately harmed students in our public education system because of the embedded stereotypes and biases that are naturally brought into the classroom and the lower expectations that many of these teachers have for students. So we are advocating for not just a stronger cadre of black educators in our public school system, but also informing those teachers who exist presently in our current school system to recognize that these students deserve the very best educational experience possible, and lowering your expectations for these students is not obviously a pathway towards that. That's just one example. We've also done a lot of research around the lingering effects of the pandemic and how that gap in learning will have a compounded effect going forward. And we hope that by exposing that and exposing the ways in which black and Latino children have been disproportionately harmed, that will help inform policy as we go forward. So having the information, having the truth and the facts, and we talked about, debunking the myths about a zero-sum calculus and who particular race-conscious remedies may or may not harm. Making sure that we expose that with actual data, actual research is going to be critical to that. And then, of course, organizing communities to make sure that parents and students and stakeholders in these environments are empowered with the tools to continue to advocate for themselves. We're seeing more and more of those stakeholders show up at hearings and show up at school board meetings and show up in ways where their voice simply can't be denied because their lived experiences simply can't be ignored, and their testimony is so searing that it is doing important work to shift the narrative from what we've seen it being mischaracterized as in many school districts.
Well, thank you so much we'll open things up for the audience questions in just a moment.
I do have a question for you,
Yes.
Bennett. As a young almost lawyer, what motivates you to continue working in this movement for educational equity, and what do you expect to see from folks like Janae and me that would help you succeed in that, going into that field?
Yeah, it's a great question, and one I've thought a lot about, because I think, especially being at Columbia, I was surprised by how few people really know what education law is. And when people ask, they really don't really know where to start in the topic. And of course, I think, well, Brown v. Board is a seminal case that all of us learned in 1L year. Why is this something that people are confused about? In terms of my own passion for this work, it started when I was in high school, and my father got very, very sick, and I was able to lean on my school. And I had teachers who I'm still very close with, who I actually found out recently, spoke with some of my other teachers to ask them to go easy on me after they found out that my family member had become sick. And so going through that process, getting very close to my teachers, having them there for me, made me sort of open my eyes and look around the classroom a little bit and start thinking about how important it is to be in this space. And it doesn't take long when you do that to start seeing inequities in the spaces that you're in. And for me, I'm from a fairly small rural town in South Carolina. You look around the classroom, there are not a whole lot of black and brown faces. I come from a town where the majority white school is on one side of the train tracks and the majority black school is on the other. And frankly, if my father had not gotten sick and I had not had to sort of firsthand experience how important teachers are, I would not have realized that. And I think a lot of people go without that realization. In terms of what your organizations can do to sort of support this work and support bringing in younger folks, I worry about two types of people. The first type are the students who simply don't know any better. They're the students I would have been if I had not had the experiences that I did. And for them, I think it's really about messaging. It's about meeting people where they're at and helping them understand how much public schools have done for them. And also, I think, the sentiment of We Are All Brown is right, which is that this isn't about any one population. Of course, this populations need to be centered. Black and brown voices should be centered. But at the same time, this is something, the effects of this go everywhere. This is something, as you said, a refounding of our democracy. It's something that everyone should be invested in and everyone should be fighting for. And I think that you have to sort of sell that message as much as possible, because especially after the pandemic, I think people are divesting from schools, not just in a political way, but in a very grassroots, family-centered way, where people don't feel schools are as important as they used to be. And then the other type of person that I worry about are the people who do care very much and simply don't have access to these spaces. They're the people that don't have the benefit of going to an Ivy League institution with decent funding to send us to do amazing events like this. And for those students, I think we need to really think about the structural pipelines for getting them into advocacy work. I think that's reckoning with the fact that it is almost an irrational choice to go into public interest work as compared to sort of big law work in terms of how much you get paid. I think it's reckoning with the disparities in access to higher education and to the legal field. So I think the focus should be on the structural pipeline and on the messaging. And with that, we shall open it up to audience questions. Now, I could ask questions to you all day, but I think we have time for just one or two audience questions. And I believe I might have a volunteer who can.
Okay. Hi. Thank you so much. My name's Catherine Powell. I'm with the White House, but very much here in my personal capacity on leave from academia. This has been a phenomenal panel and a phenomenal conference so far. I'm a former LDF attorney as well. That's my most important reason why I'm here. I just wanted to draw on what Bennett said, based on your own personal experience of recognizing the benefits of an integrated education, not only for Black students, but for white students, for all students. And the reframing, they need to reframe that, right? And I want to link this back to the previous panel when Jinhee Lee, who's a former student of mine, mentioned about the need to build alliances with Asian Americans, with everyone. And I know LDF has been very successful in the Harvard lawsuit in doing that because of the role of the Asian American students there, working with the Black students of color. That hasn't necessarily been the case across the country. And when I just happened to see, from my university that they were basically rolling back all of the race-conscious language in their admissions applications in the fall after the Harvard-UNC case came down, I was really distraught. And I work with other Black alum, Alati included, to try to, organize Black alums. When I talk with my freshman roommate, my dearest friend who's Asian American, she just said, look, I can't support this. I had my kids, Asian American, half Arab, take out their ethnic identity when they applied to college. Many Asian Americans don't see the benefits. Many people don't see the benefits. And so I'm just wondering what LDF can do to scale up what you did at Harvard so that other people across the nation recognize these benefits for all of us. Thank you.
So thanks so much for that question, and I promise you it was not planted because I've got a great answer for you. We have launched the Equal Protection Initiative, which Jen referred to on the previous panel, but a key component of that is something that we are calling the Advancing Racial Equity Alliance. When we started this initiative, it was so important for me and everyone involved in it to make sure that it wasn't just led by LDF around the advancement of equal opportunities for Black people, because that would play into the narrative that this is not something that we should all be invested in and that we are not all brown, right? So what we've done is we have invited Asian Americans Advancing Justice, Latino Justice, the National Women's Law Center, and the National Center for Lesbian Rights, because someone asked earlier about intersectionality in the 14th Amendment. And in this multiracial democracy, there is no way to get around or not reckon with the intersectionality that pervades our society. So that alliance is meant, one, to make sure that we always carry that focus and that sensibility with us in the work that we do, but also that we are presenting as a united front around these issues. So we are collaborating and strategizing on future litigation, on policy work, on narrative and communications, and on research, in addition to supplementing the work that our broader Equal Protection Initiative is doing. And what was very clear to us was, even though we're bringing in these different constituencies representing different communities, we are all coalescing around the mission of advancing racial justice through our different lenses.
I think we have time for one more question.
Hello, I'm over here, sorry, I'll stand up. So my name is Love Eden. I'm a 16-year-old junior at the Youth Performing Arts School located in Louisville, Kentucky. And it's a predominantly white institution, so I just wanted to ask, what advice would you give to students of color that feel unseen or unheard in predominantly white institutions?
I think I can take that since I also had that experience. It's a great question. I think reaching outside of your school environment is really important. It's something that I didn't do as I was growing up. My family we weren't from Tampa. We didn't have the kind of community connections that I think would have really been helpful. But I think not thinking of your life and in your school community as it, right? Like what other organization, sororities host all kinds of like teen mentoring programs or Boys and Girls Club, whatever you can do, I think, to make connections within a larger community that you do feel seen in, because the erasure is real. It took years for me to, I think, feel comfortable in Black spaces, to identify as an African American person, because that is a very challenging experience to constantly be going to school with people who just don't recognize you and the particular culture that you bring and the particular experience that you bring. So that's what I would say, is that I think if I had had more connections, if I had known like I am part of something larger, a community that is diverse and not monolithic, like I think it would have been an easier experience in many ways. So I hope that's helpful.
And can I just say a word? I want to make sure that as we talk about the benefits of integration and recognizing that we are not pursuing integration just for integration's sake, that we also recognize the value of HBCUs, that we recognize the value of spaces where students can come together and be nurtured in a very particular and intentional way that in no way undermines the project of desegregation and is really a true complement to that, and one that we need to pay as much attention to as any other project of education equity.
Great. Thank you so much.
If my panelists could come on stage before I can introduce them, I'd like to welcome them up. Great, so this panel is going to be a little different. We're going to see some Q&A, but Professor Sturm is also going to give us a lovely brief presentation on intergenerational movement lawyering. So before we get started, I do just want to give a little brief intro. So first, we have Obi Afrayi. Obi Afrayi is LDF's New York office community organizer. Obi has been an organizer for years at the city and state level. Working in various coalitions, Obi has worked on various policing and criminal justice campaigns and supported advocacy in Texas, fighting against anti-truth legislation. Obi was previously a 7th grade history teacher in Syracuse, New York. So welcome, Obi. Thank you so much. And then I also have the pleasure of introducing Professor Susan Sturm, a professor here at Columbia Law School. Susan Sturm is the George M. Jaffin Professor of Law and Social Responsibility and the founding director of the Center for Institutional and Social Change at Columbia Law. Her scholarship and teaching focuses on advancing racial equity and full participation in educational, legal, and cultural institutions. Lawyering and leadership, reimagining justice institutions, and the role of law in advancing institutional and social change. So as I said, she'll be joining us to give a little spark talk, so thank you, Professor Sturm. And we are also joined by two amazing youth advocates, Ava and Genesis. So I'll begin with Ava. Ava Pittman is the youth director of Integrate NYC. It's a student-led organization advocating for equity and justice in New York City public schools to repair the harms of segregation. Ava is a student at Metropolitan Expeditionary Learning School in Queens, where she has served as the co-president and co-founder of the Black Affinity Group and member of the speech team. So thank you, Ava, for joining us today. And last but certainly not least, we have Genesis Hatchett. Genesis Hatchett is an 18-year-old scholar who's making waves with her musical talents. She's a gifted singer and songwriter exploring various genres with a special passion for classical music. Genesis is also an active member of the Real Young Prodigies, a dynamic hip-hop activist group. With her intelligence and creativity, she's using her voice to inspire change and make a difference. So welcome, Genesis. Thank you. And with that, before we hop into questions, I will pass the mic over to Professor Sturm to teach us a little more about intergenerational movement lawyering. So Professor Sturm, if you'd like to start your chat, I'll join you.
Oh, it's nice to see you all, both in person and also online. And this is a topic, intergenerational movement lawyering, that's very near and dear to my heart. I would just say that the most moving and transformative work that I have had the opportunity to do has been when I've been working close, shoulder to shoulder, with the leadership of both students, law students, undergraduate students, high school students, and people who've been directly affected by racism and incarceration. And so what are we talking about when we're talking about intergenerational movement lawyering? That's, for me, a very personal kind of question. So what do we mean by, let's start with what do we mean by movement lawyering? We all know this, but to say it simply, starting with the disability movement taken up by people directly affected by incarceration, those closest to the problem are closest to the solution. Movement lawyering is just built around that insight. And so movement lawyers work in deep collaboration with movements that are leveraging their power to advance racial equity and transformation. I have to quote from Lani Guinier, my dear friend and an LDF lawyer, and her colleague Gerald Torres. They would call this demos prudence. And demos prudence focuses on the way that ongoing collective action by ordinary people can permanently alter the practice of democracy by changing, this is so important, the people who make the law and the landscape on which the law is made. So that's movement lawyering. What do we talk about intergenerational movement lawyering? So I here have to quote from Barbara Ransby's very wonderful book about Ella Baker. Ella Baker really understood what intergenerational movement lawyering is. Radical democratic visionary and activist. And she recognized in what she called the young and determined leaders of the Student Nonviolent Coordinating Committee, the potential for what she called a new type of leadership that would revitalize the Black freedom movement and take it into a radically new direction. She also talked with such concreteness about the role of my generation, the older generation or the more seasoned generation, and also this, even though she was not a lawyer, this really applies to those of us who are lawyers, in really building the leadership of this new generation. And she talked about the support of young radical leadership in a way that would sustain the momentum of their actions. She talked about providing them with much needed skills and resources. And very importantly, she talked about creating the space so that they could coalesce into a new, more militant yet democratic political force. She saw this emergent movement as not just a youth-only movement, but to quote her, as a genuine opportunity for adults and youth to work together to provide genuine leadership. And in her view, it was really critical that the students were at the forefront of the movement because they had experienced these issues directly, and they had the passion and the future to really move this movement forward. That spirit of really supporting and following the leadership of people directly affected was actually part of one of the cases that became part of Brown versus Board of Education. In Prince Edward County, one of those 5 consolidated cases involved a student by the name of Barbara Johns, who led a movement at the Robert Russa Moton High School in Prince Edward County, and she organized a walkout of all of the students to protest the clearly inadequate and deeply inequitable conditions between their school and the white school that was just down the block. And that movement turned into a court case that was consolidated with Brown versus Board of Education. And after Brown came down, they withstood 5 years of resistance of the Virginia state leaders that closed the school rather than integrate until they were ordered by the Supreme Court in Griffin versus County School Board to force the schools to reopen. That form of student advocacy supported by lawyers is what is needed in this next generation. And I think this really is calling upon lawyers, and I think LDF is really moving in this direction in very exciting ways, and something we need to be doing in law schools. It calls upon us to really rethink the way we do things, quite honestly. We need to rethink what expertise means. Yes, we have some legal expertise, but as I've learned from the formerly incarcerated leaders that I've been working so closely with, so do they. And they actually know how law is working on the ground, how it's working and not working in ways that we need to really pay attention to. We need to rethink how we exercise power. so that we're not making decisions only upon consultation with the people who are leading these movements, but we are creating genuine collaborations where we are all sitting at the table together, bringing our different kinds of expertise to bear, and really listening to the people who are most directly affected by the conditions that we are advocating to change. I think we really are talking also in a way that's very exciting about the future, and I think we're going to hear more about the need to integrate movements, that the movement of people who are currently informally incarcerated, the movement of people to address the school-to-prison pipeline has to be part of the process of racial equity in education, because it is the criminalization of people going to schools that are not being adequately supported that's contributing to the lack of integration and contributing to the gross inequity that continues to characterize our school system. And I'll just say that, for myself, and then I really want to hear from those who actually embody this work, that for myself, as a white woman, I'll say this, I hear many of my students and also colleagues saying maybe we should just step out, that it's like we need to just step out because we're not the ones who need to be driving this change. And I would say what I've been learning over and over again is we don't need to step out, but we need to change the way we exercise our power, that we have the opportunity to help create the platforms and amplify the voices and the impact of the people who really understand the change that needs to happen, and that share the legal resources, share the access to courts. And this means thinking about litigation as part of a much larger strategy and not the driver of that much larger strategy, but the part of that larger strategy that is being defined in close collaboration and leadership of those closest to the problem.
Thank you so much, Professor Stern. In really keeping with that idea of how we use our roles or how we exercise our power and whatever roles we play in the movement, we'd really love to hear from some of y'all in the movement. So Genesis and Ava, this first question is for y'all, but basically we'd like to get your perspective on what unique strengths and perspectives student advocates bring to intergenerational lawyering movements, particularly when we're talking about challenges related to racial justice and educational equity.
So I think that a lot of the times when we're talking about like movements that are made for youth or that should be youth centered, we're not being cognizant of like what youth need. And a lot of the times when it comes to adult allies, they haven't been a youth in like a hot second. So they're not mindful of our needs. So I think that a strength that youths have is knowing what we want, when we want it, and being very active. Like I think when it comes to youth, we don't have a lot to lose, which is why a lot of the times you've seen us on the front lines in a lot of different movements, because we're about action and because we want to take actionable steps towards change. I would think that's definitely a strength. Yeah.
I am part of the organization HHN2L, otherwise known as Hip Hop Into Learning, and we believe in putting lyrics to action. And what that means is when we see a cause and we see something that we believe in, we write songs about it and we produce those songs and we make music videos and we speak on the issues and we find different and unique ways to create platforms about the topics. And one of the many, many examples that I have would be the Crown Act getting passed in Louisville, which we took a big part in. We wrote a song called Crown, and we performed it, and we had a rally at the Capitol, and everything kind of, well, we find very unique ways to have our campaigns be known to other people, and it's just really important that we explore different outlets to be able to be heard. Another example would be a campaign that we're working on right now called Journey to Eden, which is a song that I created with my best friend, and it's about a 15-year-old girl named Dovia Purnell whose life was taken in a neighborhood called Park Hill in my city, Louisville, Kentucky. And the song is really important to me because all the emotions that come up when speaking of a girl who's just like me, whose life was tragically taken. And I think it's really important that I have outlets to use my voice that may not be public speaking, but to find different ways that my gift can be used to help.
That's amazing. Thank you all. Obi, you have something to add?
Yeah, I just want to say that there's 15 and 18-year-olds on this stage right now. Like, what were we all doing at 15 and 18? Like, it's so impressive to be on here with y'all, and the work that you're doing is so transformative. I will just say, just to add to your definition of movement lawyering, you described it as being, you describe it as being those closest to the problems or are most likely to find the solutions. And I would also push back on that and say proximity is half of the question. It's also the experience piece. I think oftentimes to the student question, we pigeonhole young people so often when it comes to their experiences within movement, where we're only trying to talk to them about things that involve schooling, as if young people don't have mental health concerns or housing insecurity or workforce development force and all these things. I think that we do need to start including young people, specifically centering them. Like when we think about what it means to censure within movement. It's not just about looking for their plaintiffs and things that people actually be in these spaces. It's about people who can actively lead, you know, taking the work that they're doing, young people creating programs, literally programs, and applying funding towards it and resources and giving training for them, and also giving them space to also make mistakes. You know, I think that's the thing when it comes to movement as well, is that we are people, we are community, and if we're not willing to ride with community and ride with our young people and give them the space to develop, that's what true equality is. Well, then we're not reproducing anything. We're just doing the same systems and just gearing it towards a different lens.
Love that. Thank you so much for contributing that, Obi. And I hear a lot about, you know, from y'all, our youth advocates, talking about how important it is to use your voice in your own creative way, and also how important it is to be heard. And then, Obi, hearing you also talk about, you know, how we need to amplify that and make sure that we're actually listening to those voices is really important. And so, Obi, I'd want to hear a little bit more from you, actually, about your work as a community organizer, specifically in engaging in intergenerational movement lawyering, and how your sort of interactions have come about in community organizing.
Definitely, and also good afternoon, everyone. It's such an honor to be here within this space, and I got to sit on some of the panels that were before. It's brilliant people in this room right now, so this is awesome. As an organizer, who's someone who's been at LDF now for a couple of years, but also is organized in other spaces, I think for me it's an understanding of our positionalities when we go into spaces. Even me, I'm a Brooklyn native, I'm a born and bred here. I don't understand, I don't speak for every Black New Yorker, you know? I have my own set of identities and intersectionalities, and I have my own sets of blind spots. I think that when we go into these movement spaces and we're working with not only just lawyers, but also researchers and organizers as well too, when we're going into spaces, who are the key stakeholders within these spaces? Who are the communities who've already been here doing this work, you know? It's so easy to rely on like headlines and data. It's like, we're New Yorkers, we've seen what's been going on recently a lot. We've seen so much about the thinking about the killing that happened recently with Win Rosario, thinking about the governor's subway plan, all of the budget fights that have been happening, the cuts to DOE, all of these things. It's so easy just for organizations just to want to get involved. But there's been communities who've been experiencing all of these pains and struggles for years, you know? People who have 9-to-5 jobs who've been coming home and founding their programs in their free time because they sensed that their communities had needs. How are we really promoting their experiences and theirs works? I think that that's a green flag that I look for when we're partnering with anyone coming into a space. And I know that we're specifically talking about the lens through lawyering now, but I'm gonna challenge us all to like really thinking about movement as a whole. As all of us who do advocacy, who go into this space, what are the things that we have to hold each of us accountable? Me, myself, as an organizer. So it's an understanding that's the first approach of like, data is so important, data is necessary, you know, like the headlines and media perspectives, all of these things, but it's the community perspectives and voices. Because oftentimes you'll go into a community and you'll be like, I wanna, for example, and not to go on a, I'm sorry, 2-second tangent, I apologize. So like we were recently trying to do some work revolving when the subway plan happened and just trying to find out from community groups what the most frustrating aspect of that response was, because you know, you heard so much about the National Guard deployment. I think that's the largest headline that we all saw, the 750 National Guards being deployed into subway spaces, things of that nature. But what we really found when talking to community groups is that they were really concerned about the mental health co-response teams that were going to be doing homeless sweeps within subway stations and things of that nature as well. And like being able to pivot what we think might be best for communities and realizing this is what communities is telling us they need us to respond to as well. That's really what I view movement lawyering as an organizer, is like wanting to build that collaboration. We're also coming from it with two different perspectives, and so are our roles within these spaces. So how are we finding a middle ground and not letting what we think is best be the thing that dictates?
I love that. Thank you so much. And Professor Sturm, I was going to ask you a similar question, building off of that idea of recognizing your positionality. What sort of learning or unlearning in some cases has to take place for lawyers to really be able to engage in effective movement lawyering, as Obi was talking about, in recognizing what you're bringing to the space and your relation to that space?
I think we've already heard from the other panelists what we need to unlearn and learn. I love this. What is the expertise that other people have, that young people have, that people directly affected by incarceration have? We know what we want and when we want it. And we know what we need, and we also know how these systems are working and not working. So part of what we need to unlearn is who knows what the needs actually are, and who gets to be part of the process of making the decisions. I think we also have to unlearn as lawyers the centrality of litigation, which is very hard because that's what you learn in law school, is litigation. And it's not that it's not important, but it cannot be the driver of mobilized change. And I'll just say one more thing that I think is really inspiring about the idea of using other venues where you can actually reconstruct the mini version of justice you want to see in a larger world. So this is why the theater and having spaces that can actually transform the narrative. Part of a Broadway Advocacy Coalition that has a thing called the Theater of Change, which is bringing together people directly affected by incarceration and racism, performers and law students, to transform the justice system. And so I'm excited to follow up, but we need to expand our view of where law gets made to take much more seriously my mentor's idea of law, which so many people have taken up. Law is not just the laws that we pass or don't pass, the litigation, but it is the relationship between the is, the ought, and the what might be. And the folks who make that link are the people in communities. That's what we need to learn.
And something I want to hear from a few of y'all about is about this idea of sort of decentralizing law as the only sort of way to social change. Genesis, how can student advocates and community organizers leverage storytelling, oral histories, using that creativity you've talked about? How can they do that to include narratives from eras around Brown to build solidarity and understanding across generations to contribute to social justice changes?
Well, I think it's very important to think about how our generation as the youth, our rights are constantly being questioned and they're constantly up for debate, and in many ways we have less rights than our grandparents, the people who came before us. And when I think about different perspectives of rights and Brown, I usually go to my granny and ask her questions, because I think so often we think about Brown and we think about desegregation as if it was hundreds of years ago, when I could literally go to my granny and ask her about a million stories she has. Because actually, she was one of the first black young women who integrated into a white school in Louisville, Kentucky. She integrated into Eastern High School. And there was a story that she used to tell me when I was younger that always struck a major chord just in my heart. And it always made me so sad. And she told me when she integrated into Eastern High School, she actually ran for homecoming queen. And that was like a big step, because there's barely any black kids in the school, and you're really gonna run against all this white competition. That's said a lot about her confidence. And she told me that she actually won. And back then it was called football queen. Now we call it homecoming queen. But she won, and on the day that they were supposed to give her her crown, they gave the crown to the second place runner-up, who was a white young woman. And I believe that just speaks so much volume to the problems that we see today, and the confidence of black students in our education systems. And I compare that with my life, because a similar situation happened to me in school. I performed all the time in my high school. I was a huge advocate. I am a huge advocate for the black student body. Every time they needed someone to sing the national anthem, anytime they needed someone to represent, sing something that's from our culture, you have all those events in high school. I would always be the first one to volunteer, and I would always encourage other black students to get on stage and educate our predominantly white institution on our history and our culture. And every year they do something called Miss Manual, which is an award that they get, Mr. and Mrs. Manual, which is an award that they give a student who advocates, who speaks up. And this year they decided that the best example of someone who encouraged excellence, diversity, and tradition was a white young woman. And in that moment, I felt very alone, because when they spoke about what she did to deserve that award, they spoke about all of her amazing performances and all the times that she's advocated. And in my mind, I was thinking, advocated for what? Because at this school, there has been so many years and so many times that the black students have felt singled out and alone. But here she is winning the award for the person who helps perpetuate the most diversity. And I can compare that with my grandma's story, and it's history repeating itself. And our perspectives over time have changed, but we can compare them and see that there's so much similar about them.
Thank you so much. Seeing those similarities, those narratives, thank you for sharing that, and also for sharing your insight of how the history repeating itself is such a common trend that we can see. And sort of getting back to the idea of not only storytelling as another avenue of change, but Obi, I wanted to ask you a bit more about community organizing as a specific, social change away from just litigation. How can community organizing work with litigation in terms of enhancing the effectiveness of legal decisions that might be successful, like Brown, ensuring that these victories translate into actual meaningful social change as opposed to just being, a court decision? And on top of that, what challenges do you see existing in that legal framework to enact that change within the communities as an organizer?
Definitely. I think that a good example of that is what's going on right now within Texas, and honestly within all of the southern states right now surrounding the education and the higher ed work. I'm speaking to some southern organizers, so I know that I'm preaching to the choir, so bear with me and correct me if I'm wrong about some of the things that are going on. But specifically in Texas, you've seen such high attacks on higher ed. Last year, LDF led a charge working with different community organizations, grassroots groups, professors, students, fighting against SBs 16, 17, and 18. For you non-Texans out here, those were bills that were set by the Texas legislature to abolish critical race theory, tenure, and DEI. And this was a rapid response mobilization to the finest. And you had students, law students, undergraduate students who were in the middle of their spring semester, holding teach-ins every single night, down at the ledge, printing out copies, hosting advocacy days, busing students in from various parts of Texas, like Denton, like parts of Beaumont. Man, a lot is going on in the Lone Star State. And this is a lot of thinking about the landscape of Texas. This is at a time when these students were also under immense personal attack. There were over 160 anti-education, anti-queer, anti-black, and anti-people of color bills that went through the Texas legislature in last session. Think about the amount of drain that is to have to fight against every single issue. And I think that's where that the narrative piece really comes into play, because that's super draining and it's super isolating, when you have all these attacks on you. The two most foundational pillars of movement, and I think I'll always believe this, are when we fight for movement, we're fighting for safety, but we're also fighting for community. And I think that's where that narrative perspective comes in. When you had students who are hosting these spaces together, beginning to talk about this is how eliminating DEI, you think that eliminating tenure has no effects on students? Here's how eliminating tenure affects me as a student at UT Austin, which has the largest black studies department within the country. Here's how it affects me as a student at a school where our multicultural center was closed and now folded into a finance office, and now I actually don't have any sort of multicultural services. Providing these actual testimonies is how you not only find solidarity within the movement, but I think that it convinces the people who, to a certain extent, we who are all in this advocacy space, we have to believe that people can move and people can evolve and change, especially when presented new information. And oftentimes the lens that we try and use is data, We talk about the numbers say this, the statistics say this, and sometimes that just causes a dissonance with people where they don't see that. But oftentimes those people can then relate to the personal stories and testimonies. They can envision themselves as a student searching for these things, or they've been the student searching for these things, and they find that commonality within that space. I think that's how you see that grow. I don't think that in terms of education in Brown v. Wardo, that's the only real space where you've seen that. You see that here within the city as well. I'm actually in a space right now where there are a couple of attorneys who actually litigated this case, but thinking about New York City and thinking about the stop and frisk work that I've gone through here, you know? So much of that work was foundational, building off of years of police killings, like Amadou Diallo, who was killed within the Bronx in 1999, thinking about all of these things. And then stop and Davis, Floyd, and Lagone happens, and stop and frisk is deemed unconstitutional. And, you know, that's a huge win. But also, like, where are we still now within our city and like what's going on within that? And thinking about the narrative work that's really picked up. You have so much more, like, there weren't know your rights trainings like that when I was growing up as a young person within the city, you know? That was still a new concept, things of that nature. There weren't conversations surrounding database-based policing and broken windows politics and all of these narrative changes. And so much of that has led to such historic wins as we saw with repealing of 50A, with the passing of the How Many Stops Act. With that's how you see the policy and the community building really support previous litigation. So I think that there's a lot of different examples. My one foundational belief, and this is not the end all be all, I encourage healthy disagreement, like that's part of what we say within this space, but the strongest campaigns are the ones that come from community. The strongest campaigns are the ones that come from community, because you need people to buy into the work that you're doing. And if they don't buy into the work that they're doing, if they don't see it as being transformative for their lives, then you're fighting a losing battle.
Thank you so much for sharing. Ava, I wanted to ask you a little bit about building on some of those challenges. So, Obi, you talked a lot about challenges between potentially that disconnect between community and that legal change. Ava, the question I have for you is about the complexity of the challenges between generations in the same movement. So, you know, how do you navigate the complexities of intergenerational collaboration? You know, you have different experiences, priorities, or approaches. How do you navigate those while maintaining a shared commitment to advancing that same social change within the larger movement?
So I think that a lot of the times, like when working with like youth and adults, there's obviously a major disconnect because like you're not consuming the same media, you're not enjoying the same things, and because of that, like you're missing each other. And when it comes to like adults being in like youth-centered spaces, a lot of the times when they try to educate, it can come off as lecturing. And like I think when it comes to like youth, we're very anti like being in spaces that like we volunteer to be in and it feeling like a school. And a lot of the times adults can position themselves as like teachers or people who like have more power when the space shouldn't be structured that way. And I think a lot of the times when majorities are in minority spaces, like they try to overcompensate by speaking. And like not leaning into uncomfortability. And I think when you lean into that, there can be a lot of growth and there can be a lot of conversation because you don't necessarily need to speak in order to process information and to hear someone. And I think that intentional silence is very powerful. And I think it's very powerful with adults because a lot of the times they're always the ones speaking in movements, even though youth have like backed it or supported it or even carried it. And I think that when they sit and they don't talk and they listen, very powerful things can happen between like the youth and the adults, especially when we're talking about like movements and organizing and trying to build change.
Yeah, go ahead, Genesis. Thank you, Ava.
I think so often the youth gets overlooked, and one example, well actually I have two examples. So number one, they've cut out affirmative action. At my school, I go to a performing arts school, which is a magnet school, and I'm going to tell you guys a little bit about that in a minute. But they've cut out affirmative action, and I am someone who has benefited from affirmative action. And I think so often affirmative action is kind of looked at as like, I'm just going to give this person of color this kind of push forward just because they're a person of color. But I've studied classical music for a very long time and I'm very good at it. And affirmative action means if I'm just as good as this white student or better, they're going to be encouraged to pick me because for hundreds of years I would have never been picked. And they've cut that out. Another thing is, in my city, there's a direct attack on black students in public schools because Kentucky legislators are underfunding our schools and they're taking away transportation, busing into magnet schools. I am someone who has benefited from busing, and when you build schools off this idea that they will always have different kids will always have transportation to the schools, and one day cut it out. That's going to have extreme negative effects on so many communities, especially the Black community, and it is. And I am someone who has benefited from the transportation, and without busing, I would not be able to attend the magnet school, and they're not giving more funding to the home schools that these Black students will now have to go to. They're just taking away opportunities from them. The greatest boxer of all time, Muhammad Ali, attended Central High School, which is in my city, the historic Central High School, which was the only school that Black kids could go to in 1890. 70% of the students at Central High School will not be able to attend next year because it is a magnet school and they're cutting out busing. So they're taking away Black spaces, they're taking away community, and so often in PWIs, you feel left out. I can speak to this so heavily, and I have so many stories of for the past 4 years of my high school education feeling so left out. And then the idea of the spaces that we've created, the communities that we've created being snatched away because Kentucky legislators don't want to fund the schools is horrifying to me.
Thank you so much for sharing those experiences and how that drives you in your advocacy. So thank you for sharing that with us. And for a second, I want to zoom out a little bit more and ask Obi and Professor Sturm a question about intergenerational lawyering at a little more broader aspect. So considering the ongoing struggle for racial equality, how can intergenerational movement lawyering and base building foster sustainable change and resilience in the face of persistent systemic barriers and setbacks that we might face?
I think that a clear way is also building up what young people who are in these spaces can also see themselves as. Because, hopefully by that intergenerational piece, the young people that we're working with today, we're doing that base building, become the leaders of movement down the line. I always say that I'm organizing to work my way out of a job. I really hope I'm not invited to the 80th anniversary event. I want to be on an island somewhere playing tennis or something, and I think that's the mindset that we all need to have as well, is that these fights are always, these are long-term fights. We're going to have wins and losses along the way as well. I think that's what we need to build towards. If we're always working towards the goal, I know that this is not the intention. So I'm going to say this both as a policy perspective, but also litigation perspective. If we're always working towards the goal that passing this bill is going to make all the change, or winning this court case is always going to make all the change, we're not going to actually make any of the change. That those are steps along the way to win those. So how are we approaching it from that lens? Because we're going to have rapid response. We're going to have immediate goals we have to build. So we have to think long-term strategy. And how are we also creating positions for our community members and our young people who are in these spaces to get the training that they need and the support they need to actively engage within these campaigns? For a lot of us who work within these spaces, this is our job to do it, and that's the T. There's a real complication when it comes to the capitalism that's involved in advocacy spaces, and the fact that a lot of times communities who are the most impacted can't engage within this work in a 9-to-5 way. They can't be at City Hall for an advocacy day at 12 p.m. because they have work. They can't be at court cases and hearings of that nature at 10 a.m. and things of that nature. So how are we creating spaces for those communities to still be engaged in those processes? How are we making our processes that make no sense? Oftentimes, like the legislative cycle, I hear that budget's going to be late again. That's very unfortunate. How are we explaining those things to community members so they can understand and engage with those processes as well? By doing those things, that's where the equity piece that you're talking about really comes in as well, is that part of the reason that we ignore young people within these spaces is because we blame them for the facts that we haven't invited them to these spaces before, so they don't understand how these spaces work. And if we're never going to address that, we're not going to see any real change.
Thank you so much for sharing that insight of creating more space and platforming those voices. Professor Sturm, do you have anything to add on that question?
That's hard response to follow. So insightful. I would just some of the things that I've learned personally and that I've observed is one thing that's really important is that those of us who are lawyers, those of us who are in positions of power, that we go to the spaces that are led by youth, and that where youth and community members are actually setting the terms, and that we go, and I thought what you said about listening was so powerful, that we go not to tell or instruct, but to learn and collaborate. And that would be a big change in and of itself. And as part of that process, one of the things that I've learned from Alejo Rodriguez, who I work with very closely, is that there's a lot of distrust of the law in communities, among youth. And we don't take that into account enough as lawyers, even though we are critical of the law. So taking time to build relationships over the longer haul, and not expecting you can parachute in and just do something and leave, but really finding the partners who are going to be long-term participants, I think that's something that we can do. I think creating spaces that connect people who are outside the system to real power, so they're the ones who get to tell the stories, not just in the media, but to the people who are decision makers and to become part of being decision makers, we can help make that happen. And I think that would be really important. And I'll just say one last thing, which I think that we really need to build in a form of participatory accountability for our decision making into everything that we do. That means bringing people into the law school as for a legal academic, to actually be part of teaching our students. Young people directly of community folks, changing what we mean by expertise, and it means for legal organizations really creating a form of accountability so when we make decisions that don't respect the needs and interests and concerns of community members, they don't have to go out and protest what we did, that they can call us to account so that we can make change before there's a need for a protest. And if there is a protest, because it's needed, that we respond in the spirit of learning and hopefully long-term collaboration.
Thank you so much. I think that's so important to think about how we can grow in a space like this at the law school even. And I know we are sort of coming close to the end of our questioning, so I want to just recognize that. But Obi, you've talked about this a little bit already, a good bit actually, about the importance of making sure the community's voices are heard and included. So could you talk a little bit more about what strategies specifically you employ to ensure that your movement lawyering remains inclusive and accessible, especially for communities whose voices might be marginalized within broader movements regularly?
Definitely. I think that in terms of like a lot of the education, so I think I talked a little bit about how I used to teach 7th grade social studies. I think I try and approach this a little bit with an education lens, less about teaching people the material itself, about like the actual data, and more about the actual system. So like one of the things that I'm really heavily engaged with right now is our budget justice campaign. Again, the money is just so important. There's a financial incentive to so much of what we're talking about here in terms of all these things. So how are we really educating and talking to people about that, you know? How many of y'all knew that like last week was preliminary budget hearings? Raise your hand here if you submitted a preliminary budget testimony. You know, exactly, and it affects every single person within this room here, and I think that's the thing there, is that we're not engaged within these things, because how do we know about them? They're not putting them on, you know, they're not public information around those things. So a lot of that kind of education, I think, has been the first steps, because then people start to be like, oh, wow, this would be something that's really great for my club to get involved with, or, hey, can you come run these budget training workshops, our attendance associations? We're doing a lot of work within NYCHA right now. So the engagement surrounding those kinds of processes have been really important. Also then building with community about what kind of coalition structure works for them. I think my favorite thing about organizing is that there's not like a manual for it. You know, there's not a one-size-fits-all approach. So you can really go into these spaces and build with community about what really works for you. Maybe you can't commit to a bi-weekly meeting, which is very fair. How many of us are on bi-weekly meetings that we don't want to be at? So that's very, very, I get you with that. But maybe there's other ways where you can get involved. Maybe you want to be more involved, like with our gangs policing work right now. We've been trying to get more community groups more heavily involved instead of the legal groups as well, to make it more like, you know, thinking about heavily impacted. Oh, I hear Sarah's voice telling me that I'm speaking too fast, and I'm going to adjust. My fault, Sarah. So thinking about like the gang impacted work that's really prevalent within our Harlem communities, our Brownsville communities, our communities in the Bronx. A lot of times they don't want to engage in legislative work, but they want to do more directly impacted work. You know, they want more resource guides, they want more town hall events, foiling yourself to find out if they're on databases. So then how are we creating those roles within our coalition structure so people can engage within the work that's most important to them and their communities? I think that's really how we're trying to remedy these effects. And then providing that safety to make mistakes. It's okay if you throw an event and nobody shows up. It's okay if, you know, you host a meeting and it ends 20 minutes early. You know, we're going to keep building and fighting towards this. So giving them the space to make mistakes and grow.
Can I speak to this?
Yeah, of course, Genesis. Thanks so much, Obi.
I think a lot of the youth is very educated about what goes on, but there's still a lot of youth that is not educated about what goes on and how much power their voice truly has. And Miss Nairi, who is one of the directors of Hip Hop Into Learning, said something that sticks with me when we were at the Crown Act rally that we held at the Kentucky Capitol. She says, it's gotta start somewhere. When I was on the bus and I was heading over from my school to the Capitol, I heard some kids say things like, I'm just going to get out of school, I'm just going because it's a field trip. And it's so important that we recognize that it has to start somewhere, because those kids may be saying, I'm just gonna go because it's a field trip, and then go to the rally and learn that there are people that are attacking the right for them to have their natural hair out, and that's something that they now want to speak about. And it's just important that no matter what, we find the will and we find it in ourselves to make sure that everyone is educated about the topics and everybody knows that they can speak on the topics, or maybe not just even speak. I like to sing about the topics. I like to write music, and I like to write songs for other people so they have opportunities to speak about the topics. You could dance about the topics. It doesn't matter. Find your gift and if you can find your gift, you can find your voice. And that's what I've done.
That's beautiful. I love, if you find your gift, you find your voice. Thank you. And I do want to take this space, if there's any questions any of our panelists have for each other at this point. I mean, this is an intergenerational movement panel, and we've got some generations presented. So if y'all want to take this opportunity, go right ahead.
I'm gonna put y'all on the spot real quick. I'm sorry. I just love to know, as like an organizer and as youth organizers, what are like tools, or like thinking about like what it went to like found your organizations. Like if they were going backwards, so you could know something like now, like that you know now that you wish you had known then. What's that one lesson that you wish you had had?
It's okay to ask for help, because I think a lot of the times when we have youth-led organizations, youth feel as if we're supposed to do it on our own, because if we ask an adult, it's no longer youth-led, or it's no longer youth-facilitated, and obviously that's wrong. And like a lot of the times when we're like talking about change, or when we're talking about specific movements, allyship is a very interesting and nuanced topic to discuss, because a lot of the times allies overstep. And when you have allyship that's unchecked, or it's not helpful, obviously, it doesn't contribute anything. But I think that when you have a youth-led organization and adults that help, it's really important. So I think that asking for assistance is very, very, very vital to a cohesive work environment. Yeah.
This is kind of similar to what you said, but I think it's very important to have the uncomfortable conversation. Like I said 100 times up here, I go to a PWI, and with that there can be so much fear in speaking out about the things that bother you. And over time, when you do your research, when you read, when you learn about your history, you go from thinking, am I making everything about race, or is so much of the stuff that we go through truly about race? And it's important that when you see those microaggressions, when you feel like you're not being seen, you speak out and you encourage your peers to speak out. And that's a lot of what I've done in high school, just encouraging others to speak out. But have those uncomfortable conversations, because you either have the uncomfortable conversations or you suffer from being uncomfortable in silence. And I'd rather talk about it.
Thank you all so much. I really just want to take a second to thank our amazing panelists, and to thank our youth advocates especially. Thank you all so much for joining us, for sharing your amazing insights.
Well, good afternoon, everybody. Let's have another round of applause for that powerful panel. So we have had such an incredible day of discussion, dialogue, debate, and discourse. Thank you so much for joining us, whether you're sitting here in the audience or viewing at home online. I also want to thank all of our speakers, panelists, and moderators. The insights and wisdom that was shared today shed new light on Brown and our charge to realize its promise. I also want to thank the teams at LDF, Brown's Promise, and Columbia Law School for bringing us together for these important conversations. I specifically want to shout out from Columbia Law School, Bennett Lunn, Anthony Mejia, and Malik Salmons. From Brown's Promise, Ari Amenikoner and Saba Barita. And last but not least, from LDF, Trisha Hahn, Kaylee Johnston, and Sarah Saw, who leads LDF's programmatic events work and will be coordinating events throughout the year to celebrate the 70th anniversary of Brown. Today we learned that the work of realizing the promise of Brown is the work that will strengthen our multi-ethnic and multiracial democracy. It will bring about a future where dignity is sacred, where power is shared, and where thriving is the standard. But we also acknowledge today that the enterprise of racial equity is under a carefully coordinated and comprehensive attack that threatens to destroy the foundational principles of equality that Brown established 70 years ago. Lawsuits like those brought by Students for Fair Admissions against Harvard and UNC are now but one of many legal attacks that we've seen in an effort to crawl back the progress being made when it comes to equal opportunity, diversity, equity, and inclusion. And so although we've relied for the past 70 years on the transformational change wrought by the decision in Brown, today we are charged to be stewards of Brown's legacy. We're charged to refound our conception of the 14th Amendment and to leverage it in this moment where the fallacy of a colorblind approach must be exposed for what it is, antithetical to the values of our multi-ethnic and multiracial democracy. That will require us to use every tool at our disposal: litigation, policy advocacy, research, community organizing, and narrative to truly realize the promise and power of Brown, because it was never meant to be relegated to the pages of our history books. That decision requires each and every one of us to breathe life into its legacy. We've spent much of today envisioning our part in stewarding the legacy of Brown, but I want to take a moment now to reflect on its history and share a story similar to the one that Genesis just shared on our last panel. Rutha Lark was born in 1936 in Charleston, Missouri. She was the 21st of 23 children and went on to have 5 children of her own. I am her oldest grandchild, and I know her as Big Mama. She proudly shared with me and my sister the story of integrating her high school in Charleston, Missouri, and the vitriol that she and her friends faced walking the hallways in those early days. She was proud to have had the same educational opportunity that had long been afforded to whites in Charleston. Big Mama passed away on my first day as ADC at LDF. For me, it was a bittersweet moment as I felt the incredible honor of joining the organization that litigated the case that enabled that powerful moment in the lives of so many, like my Big Mama and Genesis's granny. And that there was a sadness that she didn't live to see that moment. But for me, that moment also represented a passing of the baton. And today, we have been handed the baton. We, each and every one of us who have benefited from the legacy of Brown, have been entrusted to carry it forth because we are all Brown's legacy. Thank you so much for joining us today. And for any additional information on LDF's year of celebrating the 70th anniversary of Brown, please go to naacpldf.org/Brown at 70.